30. You may be called for IA. Relating to the item 30, IA is not listed. So let me call for 30. Please. Please. Regarding this case, I like to impeach this, the director of archaeology as a party. So I filed the petition. So party is the main case. Party. Court. No. I recommend we also the affidavit number, file to affidavit number.
Lordship beg to mention for listing of the writ petition for tomorrow. Your Lordship.
I beg to mention item number 33. Item number 33. The matter may come up after vacation. My senior is out of this. Then. No.
May it please your Lordships. May it please your Lordship. This batch of petitions involve a common question of law. There are other arguments as well, but there is a principal argument that the entire proceedings are without jurisdiction as the notice has been issued under the provisions of 73 and 74 in a consolidated manner and a common adjudication has been done. Whether this can be done or not is the question which we are placing for a Lordship's kind consideration. If your Lordship's will not hold, assuming that your Lordship's hold in our favor saying that this cannot be done, of course, liberty will be reserved in their favor to do it in the proper manner. It's a question of jurisdiction, whether they can have done it in a proper manner or not. They can still do it. Even today, they can do it. If your Lordships were to hold against us, then there are other 2 points that I'll place for your Lordship's kind consideration on jurisdiction itself, for pure question of law. I will not get into any facts because we are before your Lordships. I will not get into any facts. The submission is this, that the proceedings are for the financial year 17-18.
Yes. Yes.
Lordship. The submission is this, that the proceedings are for the financial year 17-18 to 21-22. A common notice, my lords, on 27th of December 23 was issued. These periods and dates may vary, my lords, in the other matters. Where others are
for 2017.
17-18 to 21-22. And the notice was issued on 27th of December 23. This is as far as item 1 is concerned.
All 73 or 74?
These are 74 months.
So 5 years.
5 years. 74, they've invoked 5 years period.
And the last date for 2017, 18, 18, 19, sometime in now.
Lordships, 21. But that was extended, Lord. Your Lordship, sir, because the COVID extension was there. That was extended. Lordships.
For 2017-18, what is the last date?
Last date, my lords, would be 31st of December 23.
31st December
23.
22,
23.
2020,
3.
23.
Lordships.
Okay. So this is well within the period for
Within the extension, Lordships.
well within the period for 73 also.
No, my lord. 73 it's barred. Is as far as 74 is concerned.
So why?
73.
Last date as for 44 is 31st of
That would have been 22. Had 74 not been invoked, for 74, the last date is 31st of December 23. 73 would be 22. Your lordships are right. Were they to issue a notice under 73? That is one of the points that we are raising for lordships consideration. That these are time barred because since they have lost out on the period under 73, they have invoked 74. Because the last date to issue notice under 74 is 31st of December 23.
there was some notification, if I'm not wrong, issued
Lordship.
by extending the period.
Lordships are right. Lordships notification 9 of 23 was issued, extending the time limit. Thereafter, notification
No,
of
that is for
56.
the purpose of completion. That is for the purpose of completion under 73(9).
Lordships. Lordships.
That under section 44, the period was extended. Initially, what was happening? After the COVID came in,
Lordships.
they started initially extending under 44.
Lordships.
Thereupon, they took another plea, which is by the notification of 9 of 2023 and later on by 56 of 2023, whereby the period under 73(9) was extended.
Lordships. Lordships.
I'm concerned with 44.
44 minutes. 40.
In terms with 44, in what time it was extended for 2017?
For 17-18, it was extended up to 22 minutes. So therefore, for the financial year up to 21-22, 17-18 notice ought to have been issued to me by 22. Under 73, if they invoke 74, what?
74 to, see, 74 says 5 years
5 years.
from the date of final submission of the return.
Lordships.
So therefore, my question is, what is as per 44, section 44, what was the period for 2017?
17. Well, that according to me is 22, but I'll just confirm in 1 minute. I'll just make a statement in 1 minute.
I have referred to it in my judgment pertaining to that 56 notification which I set aside.
Lordships.
There I have detailed out the period. That is some that I say the name of the broker.
Barabanki Lordships. Lordships.
Yes, where is that? Anybody has that ready?
I'll get it.
Because there I made a reference to 44.
Lordships.
The change which happened. Because later on they took into consideration 168.
Lordships.
68A and thereby extended the period.
Period for adjudication. Your lordships are absolutely right.
So
Absolutely.
prior to that, it's very positive thing.
I'll just get a copy of that document.
Because there I have mentioned
Your lordships are right. Your lordships have tabulated. I distinctly remember. Your lordships are absolutely right. Lordships' memory is extremely sharp. Lords. I did not see this. Ah. Lordships, the due date for the financial year 17-18, my lords.
Finally come to paragraph 18.
Lordship, I'm just reading that only, my lords. 17-18, my lords, the original due date.
Extended to February 2022 for the state of Assam. This makes the financial year 18 and 19, notification in October. People, financial. Therefore,
Lords, for the financial year 17-18,
2018, it was up till
30th September 23. 30th September 23 is the due date for issuance of the notice, my lords. And the due date for passing of the order is 31st of December 23.
First, there was a notification 6 of 2020 on 3rd of February 2020.
Lordships.
The due date for filing of the annual return for the financial year 2017-18 was extended to 7th of February 2020. Respect to the financial year 18-19, it was 18-19 was 31st of 2020. In 20. Then 2021 would be, there was no extension given.
Lordships.
So therefore it would be September.
It would be lordship. There was no
30th of
extension, my lords, for
September
20.
2021.
Lordships.
39, 2021. And 21-22 would be 39,
39-25, my lords.
2022. Last date
Last date.
is September.
September.
Yes,
Lordships.
So
Lordships,
so
sir.
44 it would be there.
30th September.
So therefore, for 17-18, the notice has to be issued. The completion period is 3 years,
Lordships.
which would end on 7th of February 2023.
So it will be 30th of September 23, my lords. So they have to issue notice as per the notification by 30th of September 23 and pass the order by 31st of December 20 for 17-8. Lordships.
How do you say that?
Lordship, the original, Lordship, let us assume there was no COVID. Let us assume there is no COVID. 17-18, the last due date for filing the return is 5th of February. Is by 5th of February 2020. 3 years, Lordships. Under 73, it's 3 years.
Filing of return.
Lordships.
And so filing of return, how?
No, my lords. The due date, the extended due date, your lordships are right, my lords. The notice has to be counted from the filing of the annual return, lordships. That's why it goes to September.
So
For that
therefore
financial
it would be 30th of September 2018.
Lordships. And 3 years there, because they have power to issue notice within 3 years.
And as per 72,
Lordships.
you have to issue a notice 6 months or 3 months.
3 months. 3 months.
So therefore, you have to issue a notice prior 3 months.
3 months prior to date of adjudication. That was extended by the notification of 2020. Therefore, the last day for issuance of the notice under 73 would be 30th September 23.
I didn't say so.
Lots. As per the notification.
No, the noteworthy to mention, you have the notification number 6 of 2020.
6 of 2020.
That is 3rd of February 2020.
Lordships. 3rd of February 2020. Lordships. Lordships have
For the
notification.
central government. Whether
Yes.
CTS.
Lordships are referring to 3rd February 2020 notification.
Yes.
Lordships. Lordship, it says that for the financial year 17-18, 5th of February 2020. Lordship may have that.
6 or 7.
7th. Lordship may take it as 7th.
Okay, it is 7. Because I have noted it down.
No, your Lordships are right. Your Lordships are right. Your Lordships are right.
So 7th of February.
7th of February. Therefore, the notice ought to be issued because if this becomes 20 by 2023, 3 years, Lordships. So it goes to February 23 and the notice ought to be issued to me by 30th of September 23. Order thereafter 3 months because they have to have a gap of 3 months minimum. That the law prescribes that minimum 3 months gap has to be there between the issuance of the notice and passing of the order.
Last date being 7th of February
Lordship.
2020. It would now be, you have to complete it by 7th of February 2023.
Lordships.
And 3 months prior to that
Lordships.
would be 7th of December.
No, my lords. They have to issue a notice 3 months prior to adjudication. So they ought
7/11/2022.
7th of February 2020. And this they have a period of 6 months from the date of filing that return. So the notice has to be issued to me by 30th of September 2023. And the order thereon has to be passed by 31st of December 2023. I think my learned friend will also agree, my lords. If I'm making any error, he can correct. These are the exact dates.
Now, I continue.
Lordships.
For 17-18, the period for filing extended till 7/2020.
Lordships.
So earlier, which was period.
Period.
17-18 period would have been 31st of December 2018.
Lordships.
Now it has become 7/2020.
Lordships.
Now you have to complete within 3 years from there.
Lordships.
The period of limitation as per 73(9).
Lordships.
And as per 73(2), you have to issue a notice 3 months prior to that.
Lordships.
So couldn't it be 7/12/2022? What do you say? If you have extended till 7/2020, 17-18. So you have 3 years to complete as per 73(9). Meaning thereby your order has to be passed before on or before 7/2023. 6 months prior, 3 months prior to that, you have to issue a notice as per 73(2), which means you have to issue the notice prior to 7/11/2022. Am I wrong? That appears to be the correct proposition. Now for 1819, it is 31.
31st December
Annual return
20.
is 31/12/2020.
Lots.
So 31/12/2020 means you have to pass the order by 31/12/2023.
3 lots.
And therefore, you have to pass the order means by September 2023, you have to issue the.
Issue the notice, lotships.
That if
Lotships.
the-
Lotships, sir.
Let us, that. So now you have been issued the notice on 27
December 23.
for all these 5 years.
All these 5 years. Adjudication is much later.
Now, as per 74, it is well within period.
As per 74,
It
lotships.
is well within the period.
It's within the period.
Now, as per the CBSK Act, for the purpose of, these are two different things. 73 is if this short paid or all these things, without the element of any suppression, fraud, or any or evasion of tax.
Lotships.
There might be a fraud, but doesn't result in an evasion of tax. It's a different. So that is 73. 74 is a case of fraud, suppression, and fraud. Now, the Telangana High Court, while dealing with one of the cases out there, had held that these three aspects are different, how 74 is there. Be that as it may. So 74 is a case of fraud, and it is other cases not nothing. Now, as per section 74, while adjudicating a proceedings under 74, if the aspect pertaining to fraud, suppression of material facts, all these things are not there, then in that regard, you can revert back to 73. You can do it under 73.
They cannot.
You can, but if it is done within the period of limitation under 73.
Lotships.
Otherwise, you can convert the proceeding.
Lotships. From
If-
74.
Because here the penalty to the case on 74, that is the.
Lotships. That's the submission, my lords. They are invoking 74, having missed 73, because their penalty is 100%. That's the precise submission, my lords. And that has been considered. I'll show to your lordships, my lords. I'll satisfy your lordships on Telangana High Court also, my lords. This, my lords, as an officer of this court, may I make a submission, my lords? This very issue, lordship, the submission is this: whether 73 or 74, whether there is fraud or suppression is certainly not a question of fact, whether there is a fraud or no, or whether that fraud results in evasion or no. You are as rightly pointed by your lordship. The submission in law is whether they could have done this in a consolidated manner or not, whether it affects the adjudication and the issuance of the notice or not, and goes to the root of the matter or not, whether it prejudices the assessee or not. And, my lords, I am going one step further. I will satisfy lordship. It prejudices the revenue also. And the scheme of the act never contemplated this. The scheme of the act contemplates financial annual assessments. It's exactly based on how income tax is for so many years. It's exactly modeled on the erstwhile sales tax law. This is precisely the reason, my lord, the states are nowhere opposing. States are doing this. Only center, my lord, the center officers, my lord, with great respect, they were used to, under the erstwhile excise law, under the erstwhile customs law, even customs there today, erstwhile service tax under the Finance Act, there was no provision for adjudication. There was only a provision for issuance of a show cause notice within 5 years from the relevant date. It was not based on assessment, financial year assessment, or return based. It was not based on returns. And what they were doing under the excise regime was correct. They have extrapolated to the GST regime without, with great respect, understanding that the scheme of the act is now different. The scheme of the act now provides for a tax period. A tax period provides for filing of the returns. And all actions, whatever actions they can undertake, are based solely on your returns. That's our submission, Manoj. And Manoj, with great respect, this submission has been accepted. Manoj, by the Honorable Madras High Court.
You have cases in your favor which is being supported by the Madras, Kerala and Bombay.
Manoj, Madras High Court, the Kerala High Court, the Bombay High Court, Manoj, the Karnataka High Court, the Andhra Pradesh High Court. All courts have unanimously taken this view. And I'll deal with Telangana High Court also, Manoj, and the Delhi High Court also.
Telangana
Different, Manoj. I'll deal with the different
on the
of
Telangana is on the issue as to when you can invoke 74.
74.
That is not the issue.
That is not the issue before you lodge, Manoj. Manoj, I'll
But you have judgment where the Delhi High Court has been continuously holding. The High Court has been holding against you.
I'll show that, Manoj. The Delhi High Court, Manoj, with great respect, as an officer of this court, I must inform your lordship, which they will also not inform your lordship. Manoj, what had happened, the Delhi High Court had taken somewhat contrary view in specific facts. Manoj, may I just point out that first? In specific facts, the Delhi High Court, in my respectful submission, did not lay down as a proposition of law. One. Two, Manoj, let us assume your lordships were not to agree with me on this point. I'm saying that no, Delhi High Court has laid down a proposition of law. Let us assume so. Let us assume like that. It has been dealt with by all the other high courts and a view has been taken. It has been considered. Third, my lords, most importantly, one of the assessees, my lords, from Delhi jurisdiction, my lords, approached the Honorable Supreme Court directly under Article 32 petition, saying that, sir, what is going on? I am an assessee in Delhi. I am governed by Delhi High Court. I am bound by Delhi High Court. The Madras High Court has taken a view. The Andhra Pradesh High Court has taken a view. Therefore, where do I go? Because I will be governed by Delhi only. The Supreme Court allowed him to go back to the Delhi High Court, show the Delhi High Court, the Madras High Court view, the Andhra Pradesh High Court view. And subsequently, the Delhi High Court itself is reconsidering that issue. I'll show that to your lords. I'll show that to you. Actually, on the last occasion, I had given a paper book. At that stage of admission, when your lordships were issuing notice, I'd circulated a compilation. This is subsequent. All is subsequent to that, my lords. It's happening. It's happening. Your lordships may kindly have page 3 of this paper book, my lords. Your lordships have page 3?
Yes.
I'm so sorry, my lord. I'm so sorry. After our lordships have that. After arguing the matter for some time, Mr. So-and-so learned counsel appearing for the petitioner seeks to leave to withdraw this writ petition filed under Article 32 of the Constitution of India so as to approach the High Court. The petitioner will be at liberty to bring to the notice of the High Court the decisions of the Madras High Court and the Andhra Pradesh High Court, and it can be considered and disposed of by the High Court on its own merits. They were alive to this, my lords. And then your lordships may kindly have page 1 now. Kindly have page 1, serial number 1, page 1, my lords. The same bench, my lords, with great respect. The present petition has been filed inter alia challenging the order in original dated so-and-so, whereby a demand of so-and-so has been confirmed against the petitioner for the financial year 17-18 to 21-22. The issue raised in this case is about a consolidated notice being issued for multiple tax periods. This court has already taken a view in Ambika Traders, which was upheld by the Supreme Court by the order dated so-and-so in SLP. Learned counsel for the petitioner, however, points out that in view of the decision of this court in Ambika, the petitioner approached the Supreme Court in writ petition so-and-so titled as so-and-so, wherein by the order dated 7th October, it was directed as under. That entire order is reproduced, which I just now showed to your lordships. In view of the above, let the copy of the concerned petition filed before the Supreme Court be placed on record. Let written submissions be filed by the petitioner before the next date of hearing. List the matter on so-and-so.
And what about the Mathur polymers?
Mathur polymers. Mathur polymers only followed Ambika. Mathur polymers simply followed Ambika. What had happened, Manoj, I'll tell you lordships. Ambika, the petitioner moved the SLP before the apex court and withdrew it. It was not, there was no decision by the apex court. He withdrew the petition in the Supreme Court.
In this case.
In Ambika.
But no, but because it has been issued.
Lordships.
But
Mathur, my lords, the SLP was dismissed by the apex court.
Was dismissed and
Lodge.
the SLP was filed and the court said we don't find any illegality of, although
Lordship.
any illegality on that very aspect shall be done by Supreme Court. So therefore, whether that aspect was brought to the notice, because you withdraw and then the Delhi High Court reconsiders, it's a different aspect. But the Delhi High Court on Mathup, Polyamid or Ambika
Lordship.
considers in the aspect of, yes, I am in agreement with you that when there is a case where 4 or 5 periods are being taken together, of which some are aspects pertaining to, but Ambika was the case of IPC.
Lordship, that's my submission. Ambika was not
But Madhu Polyamid was not a case of IPC.
ITC only.
No.
Lordship, may kindly see. I'll show it to your lordship.
Madhu Polyamid, categorically mentions with very aspect to the matter. Yes, it was dealing with IPC that is there.
No, kindly see, my lords, Mathur at page 92. I'll satisfy your lordships. Kindly have page 92. Lordship, this compilation was there at the first instance. Page 92 of this compilation. Lords.
Which company?
Lordship, at the time of admission, I had given a compilation. This is subsequently what all has flowed. Lord. Yeah. The court officer had it.
It is given by whom?
Page 92, your lordship. Sir.
Yes.
Lordship, sir, Mathur, my lords.
When you come to paragraph number, page 97, down below, after paragraph 9.
Lordship, may kindly have page 96 first. Para 21.
I'm looking. When you come to down.
No, my lords, there it starts. Para 21 heard. Para 21, lordships have heard. This court has in the past considered several order in originals demands on the ground of the allegation of fraudulent availment of ITC and held that several factual issues in such cases which would need to be looked into, which cannot be adjudicated in a writ petition. In the decision in Ambika, in this context of issuance of multiple and passing consolidated order, the court observed as follows. Then at page 97, my lords. Kindly have page 97, just above para 22. Same case was there, my lords, just above para 22. In the above decision, the court has fully considered the statutory scheme as also legislative history of CGST Act and held in cases relating to availment of input tax credit, considering the maze of transactions and due to the fact that transactions may be spread over several years, issuance of a consolidated notice for multiple financial years would be permissible and tenable. In this context, the Delhi High Court clarifies. Para 22.
Mr. Counsel,
Sorry.
Mr. Counsel, I
I'm
have
so sorry.
difficulties on the basis that if it is a case of IPC, you can very well segregate and have a consolidated. In others, it is not.
No. I'm submitting that.
It cannot be. It has to be whether you can or you cannot.
Lordships, my submission
See,
is that.
the Madras, Kerala, and all these high courts have held only one thing. Let's look here. The concept of a consolidated, what we call the so-called notice is not contemplated under the GST.
Lordships.
This is the basis on which it is being done. Whereas the Delhi High Court has looked into in the context of Section 73 and Section 74 and say that the use of the words further periods which have been mentioned is the basis on which we are going to look at.
Lordships.
So therefore, it does not say, the legislature does not specifically mention that this is a particular year or the financial year is the question. It says about further periods. The further period may encapsulate many other periods also. Provided, whatever may be. My opinion is, you see, it cannot be only for ITC or anything. My only thing is, if what is the problem in issuing a consolidated so-called notice? If you can very well write it, yes, if there is a prejudice being caused to you in the sense that it is not, the aspect is not clear, and thereby you are not being afforded, yes, there might be a good reason for interfering with that. But otherwise, what is the prejudice? I'm on that.
Lordship, may I just satisfy your lordship? Because here, as rightly fell from your lordship, whether it is relating to classification, valuation, input tax credit, we are on law, whether they can or not. Because very simply put, whether they can do this or not. In our respectful submissions, they cannot. They have to satisfy your lordship that they can. Because to answer this question, I have a twofold answer. One, if it is without jurisdiction, I need not prove prejudice. Supreme Court Maruti Suzuki Honorable Lord Justice Chandrachud will satisfy lordships. If the proceedings are without jurisdiction, they are contrary to the law, contrary to the procedure laid down in law, assessee need not prove any prejudice caused to me. I need not prove any prejudice. What is the prejudice caused to you if I answer this notice? No. The question is whether they can or not. If they can, lordships, I'll walk out of court. If not, then they have to do as per law. That's the short point, my lords. Second, I go further. I show prejudice to your lordships. Not one, but 10. Not for me, for them.
I'm not concerned with that.
I'm lordship. I'll show.
Let
Lordship,
us be satisfied with the
Lordship,
petition.
kindly see the recent judgment of the Karnataka High Court, which has considered all this, my lord. I'm placing as a part of my submission. Serial number 4, Pramur, my lord.
Show me where there is a bar. From that.
Lordships.
From the act, show me the bar.
Against, my lord, may I just answer? Lordship, may kindly have the section. Kindly have the section. Kindly have the section.
74.
74, 73, 74, both are, my lords, identical in that sense, except the fact that one says fraud, other doesn't say. Kindly have 74, 1, my lords. Where it appears to the proper officer that any tax has not been paid or short paid or erroneously refunded, or where input tax credit has been wrongly availed or utilized by reason of fraud, willful misstatement, suppression of facts to evade tax, he shall serve notice on the person chargeable with tax, which has not been paid or short paid, or to whom refund has been erroneously made, or who has wrongly availed or input tax credit, requiring him to show cause as to why he should not pay the amount specified in the notice, along with interest and penalty. The proper officer shall issue the notice at least 6 months prior to the time limit specified under subsection 10 for issuance of order. What you may kindly have, my lords? 3. This is what fell from my lords, my lords. Where a notice has been issued for any period under subsection 1. What is this term? Any period. Under 1. The proper officer may serve a statement containing details of the tax not paid, short paid, erroneously refunded, or input tax paid wrongly for such periods other than 1 on the person chargeable with tax. I pause here for a minute, my lord. This is, my lord, 74.3 is a subsequent, is all subsequent periods. I'll tell your lordships why. The similar provisions were there under the erstwhile laws also.
For any period under subsection
1,
the proper officer may serve a statement
lordships.
containing the details of tax not paid to import other than rules covered in the subsection
1. Lordship. So, for example, lordship, I'll give an example. Suppose a notice has been issued for 1718 under section 74. Lordship, let us assume, forget this clubbing for a minute. Let's just assume. Simple example I'll give you, lordship. Suppose a notice has been issued for 1718 under 74. 74 saying that you have suppressed the turnover for 1718. A notice has been issued. for the same issue, let us assume, for subsequent period, 1890, for 1890, they have to issue a statement under 74(3). And kindly see 4 now. The service of a statement under 3 shall be deemed to be service of a notice under 73(1). Why? Milords, because with knowledge, suppression ends. Once I invoke 74, for subsequent period, there cannot be 74. It has to be 73. It has to be 73. It cannot be 74. This is one of the arguments, my lords. One, they consolidate, my lords, for 5 periods, 74. For the first period, the moment they know, for the subsequent period, it has to be 73. That is precisely the reason they cannot give me a consolidated notice. And when the legislature says for such periods means 1819, 1920, 2021, it does not contemplate a single notice.
So, reading out section 74(3) and 74(4) so that a notice is being issued for a particular period, the proper officer also has to give in respect to the other people where there is no faith, but element of fraud in all the
Lordships. Lordships.
74 also that the moment you put the notice on the 74(3), the remaining period which is not there, which is not encapsulated under 74(1), shall be considered to be a case falling under 73.
Lordships.
Unless, again you see here, except, like upon understatement, except the ground of fraud or any willful statement of so and so other than those covered under alia are the same as mentioned in the earlier notes.
For periods other than 1.
So for the period other than those covered under subsection
Are same as mentioned in the
same.
earlier notice.
as I mentioned. So this is 74(4) in the deeming provision.
Lordships.
By 74(3), when you issue a notice,
Lordships.
you mention the period for which you are issuing the notice under 74(1).
Lordships.
And in respect to the remaining period also, you are to mention whatever amounts have been paid or not paid or whatever short paid and all. That period, by deeming provision, unless it does not come within the ambit of fraud for the remaining, by deemingly, it would be a case under 73
73(1).
for the remaining period.
Lordships. For the that's why submission was for the subsequent period. It cannot be that they issue a notice. Lordship, it cannot be that they issue a notice from 2017-18 to 21-22 under 74. They cannot. One, if they do, Lordships, if they do, then 21-22 is 74. 22-23, when they have to issue a notice for 22-23, 23-24, that will be under 74(3), not under 74(1). And that notice will be deemed to be a notice under 73(1) because there is no suppression. Manoj, I'll tell you, Lordships, why. The scheme of the act is with knowledge. Suppose I know that you have suppressed. You cannot keep suppressing every year. And now I know. As a tax officer, now I know that you have suppressed for 17-18. So moment I invoke 74 for 17-18, I cannot invoke 74 for 18-19. That comes under 73. So I will issue a notice because grounds will be the same. That's why 74(4) says the same are mentioned grounds in the earlier notice. So for example,
The council is very difficult to accept what you are submitting,
Lordships.
taking into account Just for example, the 1718, a person concerned suppresses a particular fact.
Lordships.
You have 3 years to do on 73. You have come to learn at a later point of time, within that period of limitation or within the extended period as per 74. That for 1718 he has done, 1718, 19 also has done, 1920 also he has done.
Lordships.
So why is it not possible?
No, my lords, my submission is that your lordships are right. For suppose during the extended period, let's assume for 1718, forgetting the COVID extent, by 2020, notice ought to have been issued under 73. But in 2021, they come to know.
No, it is a case of fraud.
Fraud. I'm coming to fraud, my lords.
Can say a reason of fraud
Lordships.
or willful mistake
Lordships. They come to know in
or
2021.
suppression of fact to evade tax?
Lordships.
If these are there,
Lordships.
so 1 year, okay, but within this extended period of 5 years, which I have, and I find out that yes, there has been a habit, there has been a willful misstatement has been mentioned.
Lordships.
It is a case where there is a suppression of facts, certain things which are there has not been shown at any point of time.
Lordships.
And later on the basis of some investigation, I come to learn that this has happened. So it therefore encapsulate these 4-5 years from these investigation or these search or seizure which has been found out there, that there happens to be these things which will show that from 2017-18 they are doing. What stops them? So therefore, 74.4 say, if you don't say that 70, if you are putting to a, under the notice only under 74.1, and you say that in respect to other period, you just mention it as per 74.3, then it shall be deemed to be a case falling under 74.4. It will be deemed that it will be a case falling under 73.1, unless, again, here, therefore, the deeming section against it, unless you put it in that very notice itself, that these are the other periods for which you are mentioned. Because the moment you are submitting, your case you are submitting 74.1, a person issues the notice under 74.1, and thereupon the next thing which comes is, they have to at that point of time also mention that other periods.
Lordships.
As per 74.3, you have to mention the other periods. Just for example, 2017-18.
Lordships.
Here the notice has been issued on 27/12/2023, which is well within 474 purpose.
Lordships.
Now, in the second portion, the second aspect which comes is 18-19. Now you have to, as per 74.3, you have to mention the first period which falls under 74.1.
My lords will not be because
No. You as per 74.1, you have to mention the period.
Lordships.
So as per 74.3, you have to mention the period of 2017-18.
Lordships.
Now, in the 74.3, you have to, if you are giving in the year 2023, you have to mention the other periods, which are subsequent.
Subsequent, lordships.
Now, if you mention the subsequent, there is a deeming provision by which it will fall under 73.1.
Lordships.
Unless you say that these are the periods, then also there is a case of fraud and thereby breaking within the ambit. So a conjoined reading of 3 and 4 therefore says that you have to have a multi-prone and what you call a consolidated notice for this period under 74.
No, my lords. My submission is that even plain reading of 74.134 talks about period. So I have no difficulty. Lordships are right. Let us assume, my lords, they want to issue a notice under 74 for 17-18. They want to issue a notice under 74 for 18-19. They want to issue a notice under 74 for 19-20. Thereafter, my lords, once the notice has been, let us assume for these 3 periods, notice has been issued. Then they cannot allege suppression. Then the notice will be deemed to be under 73.1 for subsequent periods. For these 3 periods also, if they have to issue a notice to me, there has to be a 74 notice for 17-18. There has to be a 74 notice for 18-19. I'll show your lordship. Lordship may kindly say 10. And I'll show the scheme of the act. The word period has been defined. That's my submission, my lords.
Let us see 74.
Lordships. Lordship may kindly have 7410.
Yes.
Proper officer shall issue the order under 9 within a period of 5 years from the due date for furnishing of annual return for the financial year to which the tax not paid, short paid, input tax credit wrongly availed or utilized relates to, or within 5 years from the date of erroneous refund. Therefore, one of the scheme is that he has to pass the order within 5 years. And therefore, he has to issue a show cause notice within a period of 6 months. Minimum 6 months gap has to be there between the show cause and the order notice. That notice has to be issued for a tax period. Tax period notice. Now, the only issue that your lordship have to decide whether the tax period has to be a financial year or any period within that financial year, or it can go beyond financial years.
No, Mr. Counselor, when the very section out there uses year
Lordship.
in one of the subsections and financial year in the other section,
Lordships.
that itself clearly mentioned that the legislature had given different interpretation for both.
Both are defined, my lords. I need not labor, my lords.
Let's see.
My submission is when it says period within that financial year. Lordship may kindly see. Kindly have section 2, 106, my lords. Lordship may kindly have 2, 106, my lords. Tax, your lordships have that? My apology. Tax period means the period for which the return is required to be furnished.
So where is the word tax period in 74.4 or 74.3?
Lordships?
Where is the word tax period
Lordship,
appearing?
period.
Period and tax period?
No, your lordships are right. Your lordship have to interpret that. Lordship, your lordship have to interpret that. Lordship, the entire scheme of the act is return based. I need to file a quarterly return or a monthly
Yes.
return.
And
an annual
Mr.
financial-
Counsel, I appreciate
Lordships.
that, yes, for the period. Therefore, my first question out here was to ask you, what was the period for?
Lordships.
Now, if it is a case coming under 74, or not come under 74, but the case coming under 73, the period is 3 years.
3 years.
And if it is because 1718 otherwise would be barred,
Would be part.
taking into account there was no extension being granted, so the notice having been issued on 712 would be barred for 1718. There's no quarrel with it. But if it is a case under 74, it will come within. Now, let us take the example. It's a notice under 73 for 5 years. Of course, it can't be 5 years. 73 it can't be.
Cannot be 5 years.
It
3
has to
years.
be
3 years. Lordships.
It's a case of 3 years, but of which one is barred.
Lord.
Now, unless it can be shivered, it can be shivered in the sense that one portion of it, yes, both are, just for example, in the case of that Mathur Police or Ambika, the case is that if we look into section 41 of the CDSC Act, it says that the aspect of two aspects. One is availment and utilization. For the year 2017-18, you may avail the input tax credit, and you may utilize in 2018-19. But it may be for 2 years. So therefore, that is why you get some justification in Ambika and all. But if it cannot be severe, then the entire so-called proceedings has to fall.
Has to go.
Has to. But if it can be severe, just for example, yes, they should have, but it has no continuity. These are separate. These are in silos, by which 2017-18 in this, 2018-19 this area. But they have, for administrative exigency, they have issued only one so-called. Then obviously, if one portion is barred by limitation, that may be severed out there because the others can stand on its own feet. That is what I understand. But if it is cannot, if it touches on that and one cannot have it existence without the other,
Lordship.
then entire proceeding
Has to go.
is the basic philosophy higher. I don't know what you want to say, but this appears to be what is the feeling. But Mr. Counsel, I don't find, yes, 73, 7410 has to mention that there is a requirement of the financial year.
Lordship.
If it is not mentioned out there, the financial year expected to be mentioned, then it would impact 44,
Lordship.
39, as well as also the very 74.2,
Lordship.
74.2 becomes bad, 74.9 becomes bad, 74.10 becomes.
10 becomes bad.
So you have to have the financial year concept for the getting the benefit of what you call
Lordship.
itemization.
Lordship.
So therefore you have. But I don't find here that there is a requirement that it cannot issue. But yes, the moment it touches on something which will impact you somewhere, then obviously, yes, there might be a case. That every year when you are required to issue this notice, or whenever you issue this notice, you have to be clear on the facts. Therefore, it says 74.3 says categorically. Then look here, you have to give the details of tax, penalty, whatever may be there for which this is. In fact, the bringing into effect of the DRC 01A also makes it very clear that these are various details which are to be furnished prior to issuing a DRC 01. So therefore, here you are mentioning about this particular period which is being mentioned out there that this is it. Now, if you issue out there, yes, you find yes, there is a habitual. There might be a thing that okay, I can issue 5 things, but if it is not clear, the allegations are not clear, the details are not being given, thereby you are prejudiced. Obviously, it has to be interfered. I'm with you,
Lordship.
but not on the basis that cannot.
Lordship.
So therefore, I find it difficult to accept that there cannot be a consolidated local notice, or it can be a consolidated if it's a case of IPC, but for not for others. No, it is the fact is the law is law.
No, that may not.
That's law
I
is law.
also think
So
so.
whether it will come or not, yes, if you issue, it cannot be prejudicial to you for you not to understand what is the scope or what is being mentioned. Yes, if it is so, then it. Now, if one has to fall on the other, then the so-called notice is bad, the entire thing will go.
Lordship.
And that will only save those portion of it which are remaining left on the date on which it is there. This is what I understood.
Lordship. Lordship, may I just one second? I'll satisfy now. Like, can you read Manoj again, Manoj 74:10? 10.
Yes.
And 74:1 read with 2, 3, 4, 10. Lordship, all these talk about the financial year. The
74:10.
Lordships. It does not say financial years.
Obviously.
It says the
But-
financial
No,
year.
financial, if you mention financial years, that it would have a serious consequence.
Lordship.
Because how will you have the limitation? Because you now, therefore, I'm saying come back to 44.
Lordships.
44 says that you are to submit your annual return on or before this particular date.
Lordships.
And your financial year, it's
Lordship.
from the date of filing, furnishing of the annual return.
Therefore, my lord, my submission is once it says it talks about the annual return pertaining to that financial year, there has to be an adjudication for that financial year. There cannot be a consolidated adjudication for financial years. This is what is happening, my lord.
No.
This is what is happening. They are adjudicating a consolidated demand for 17, 18, 18, 19, 19, 20. It is not an adjudication for the financial year. The financial year. I'll show my lord several places.
Then why it is not mentioned in 74.9?
74:10 says, my lord.
74.9 doesn't mention because 74.10 is in respect to limitation.
Lord's limitation.
But 74.9 is for the purpose of passing a order.
Issue an order.
Which it shall determine after considering the representation every
The proper officer
determine the amount
of tax, interest, penalty due from such person and issue an order.
So,
That order is under 74:10 for the financial year.
No. Order is under 74.9.
10:10, my lords.
74.10 is not the order.
Lordship,
Shall
your
issue the
lordship is
order.
right.
No, I'll see.
Your lordships are right, my lord.
7410 say the proper officer shall issue the
The
order
order under subsection 9, lordships, under
So the
subsection 9.
To issue the order is under 74:9
Your lordships are right.
and 74:10 gives the limitation of this.
For that financial year.
Because
That means you have to have 5 orders for 5 financial years. You cannot have one order for 5 financial years. That's my submission. Now, kindly look at form. Kindly see the form. Their own form. It gives an answer. The states had this monots forever. The state VAT Acts had this forever. Kindly have the form DRC 01 and form DRC 07. Kindly have the forms under the rules. Lordships have page 449, or I can give my book. Lordship, in this book, I do not know which.
You are referring to which form?
I'm referring to form DRC 01. That is the form for issuance of the show cause notice. DRC 01. This is under rule 142(1). Lordships have that. Lordship may kindly see form DRC 01 under rule 142(1)(a) to so and so tax period. They have to write the tax period and financial year, not years. So the tax period within that financial year. 1. 2. Lordships may kindly see even the form DRC 07 for passing of the order. It talks about order number, order date, financial year, tax period from so and so to so and so. It doesn't say financial years. And this is not a figment of my imagination, my lords. I'll show your lordships. Kindly see section 65. Kindly have section 65. It is not a figment of my imagination. It is their creation. And they are bound by it. Kindly have section 65, my lords. It provides for audit. Your lordships have page section 65. This has not been pointed out to the Delhi High Court, my lords, with great respect. Lordships have page 65. Audit. The commissioner or any authorized officer by special or specific order may undertake audit of any person for such period. Lordships may now note this also. This is the same thing as under 73-74. I'll show you your lordships. They are treating it differently. Here there is no time limit specified. Kindly see. For such period, at such frequency, and in such manner as may be prescribed. Lordship. Kindly see the rule. Kindly see the rule, my lords. Kindly have, my lords, rule 100. Sorry, 101. My apologies. Rule 101. Lordships have that. Period of audit to be conducted under 1 of 65 shall be a financial year or part thereof or multiples thereof. Multiple financial years. They can conduct audit for multiple financial years at the same time. Now kindly see the form. Kindly see the form, my lords. That is ADT 01. Lordship, may just give me 1 second. My apology. My apology. page 418, my lords. This is form ADT 01. Lords have that. Lords have that form. Please do. GST number, name, address, period, financial years.
ADT 02.
01, Lordship, 01. I'll show your Lordship 02 also, but kindly have 01. Lordships have that? Lordships.
On the part of the court
No, Lords, these are part of the act. This is part of the statute, the forms. Lordship, your Lordships. My submission, Lordships, but Lordships put me a direct question. Why I am stressing on the word the financial year is because when they wanted to say for 65 audit, they say such period. Such period means multiples also. So audit can be conducted for 5 years, 6 years, 3 years, 4 years. Because it's an audit undertaking exercise. Notice.
Sir, tell me one.
Lordships.
Let's take the example that from 2017 to 2021-22.
Lordships.
They make a search and figure and find out that yes, there's a case of understatement.
Lordships.
How will they issue notice under 74(3) for each financial?
No, not under 74(3), under 74(1). Under 74(1), that's my submission, my lords. Your lordships are absolutely right. They will issue notice, my lords. Lordships.
As regards 74(3).
My lords, 74(3) will be for a period not covered by 74(1).
So how will they? They would not be mentioning anything.
No, my lords. For 17-18, they will issue under 74(1). 18-19, 74(1). 19-20, 74(1).
Understood. Moment 74(1) is being issued.
Lordships.
Are you saying that for the remaining period, they will keep nothing, they will not mention anything?
No, my lords, they will mention 74(1) only. For the period subsequent to 74(1).
2017 to 2022.
Lordships.
2017-18, they find yes, 18-19 also on issues of investigation. Now, if you see 74(3), say, other area, other period, there is no case on in respect to evasion of tax and all, you are to mention also in that form. So 74(1) is for 17-18. So the other periods, they would not mention in the notice. So what they will do is, they will issue the second notice, third notice, fourth notice,
Right.
but they would not mention what is 74(3) is not required.
74(3) is not invoked. 74(1) is invoked.
Understood.
Yes, your lordship.
But there is a requirement also as per 74(3) to insert the other periods.
Not required, not
Yes.
necessary, my lord. Lordship, may kindly see.
Kindly see.
Kindly see, not necessary, my lords.
Where a
Notice has been issued for any period under subsection
subsection
1. Actually, I'll pause it for a minute. May I just make my submission?
No, don't pause.
Sorry.
The proper officer may serve a statement containing the details of tax not paid, short paid, or erroneously refunded or input tax credit wrongly availed or utilized for such period other than those referred under so on the person chargeable with tax.
Lordship.
Meaning thereby, when you issue a notice under 2017-18 in respect to the remaining period,
Lordships.
you have to mention it. Statement.
For subsequent period, 74(3).
Now, the moment you don't if you mention it, it comes under 73(1).
Lordships.
Unless you say, well, now see the giving provision under 74(4).
Lordships.
The service of statement under 73 shall be deemed to be a notice, service of notice under subsection 1 of 73.
Lordship.
Meaning thereby, in respect to if you put it in the statement, which is given out there, for the other period, then it will be a simple case under for assessment to be carried out along with interest.
Lordships.
No penalty is involved. Now see, subject to the condition that the grounds relied upon in the said statement, except the ground of fraud, so and so or so and so for a period other than those covered under subsection 1, are the same as were mentioned in the earlier statement.
Lordship,
So therefore,
Lordship,
when it the notice, it will be for the remaining period, automatically
Lordship.
it will be a notice under 73(1).
Subject to, Lords, that's my submission. Subject to the condition, no, my lords, it doesn't become automatic.
No, it would automatically become a year under 73(1)
One.
unless
Unless, yes,
case of fraud is
yes, my lords,
sale,
absolutely.
and once fraud comes in,
Then it's a statement of 73(3), 74(3) only. That's my submission. Your lordships are right.
Therefore, in a case where it is 5 years, you
Lordship.
don't mention the other people.
Lordships.
That is not what.
No, lords, my submission, no, my lords. Your lordships are absolutely right. What my submission is, for 17-18, they will issue a notice under 74(1). There is fraud. That is assumed. There is fraud according to them. 18-19 also there is fraud according to them. 19-20 also.
But by issuing the notice, they did not mention about statement for the period. Yes. If
74(3).
it is only 1 year concern, just for example, we are concerned with 2021-22.
Lordships.
For 21-22, the period will arise only on the month of 22. It will be in the month of December.
Lordships.
31st of December 2022 will be the last date, and you are to do it so and so.
Lordship.
So you mention only 2021-22.
Lordship.
You don't need to mention the subsequent period
Lordship.
in the statement. But otherwise, you are mandating in the law that when you are mentioning a period of 2017 only, there you have to mention also the other periods.
And under 74(3).
The moment you mention it, and you don't say that you see these 73 periods also are in case of fraud,
Fraud, Lordship.
you are exempted, or you are barred from initiating a proceeding under 74.
No, they can. That's, my lords, kindly say 74(4) is a subject to condition. Today, my lords, today what they are doing, my lords, today what they are doing, for 4 years they are saying 74, consolidated note 74. Same thing they can do for the first year 74(1), second, third, fourth, 74(3), 74(3), 74(3) with fraud. Therefore, 74(4) doesn't apply. This is exactly what they are doing today. And that's my submission. They ought to do in this manner and this manner alone. They cannot consolidate, my lords. They have to give me a statement. I'll tell your lordships why also. I'll satisfy lordships. There are so many things which flows from this. As an assessee, I will be prejudiced if there is a consolidated notice and a consolidated adjudication. I'll suffer in appeals, amnesty schemes, under compounding. I'll show you those provisions to your lordships, my lord. Every scheme of the act requires financial year wise. If they do it financial year wise, my lords, I will have several remedies. I will not have to suffer, my lords. Lordship, let us assume there is a consolidated demand. For appeals, I will have to deposit 10%. 10% of the consolidation. For example, if they would have done, lordship, suppose they have done for 17-18 separate assessment, 18-19 separate assessment. Assuming, my lord, for 17-18, I find that the amount is small, etc. I don't want to contest. I will not file an appeal. But by doing this, I will have to file an appeal for the entire period, for this period. 1. 2, I will show your lordships under 128A, the amnesty scheme also provided financial year wise. Not only this, kindly have 74A now. Kindly have 74A. Kindly have 74A. The legislature itself talks about financial year wise, my lords. Kindly have 74A. All this was not there before the Delhi High Court, my lords. This is subsequent. Lordships have 74A. Lordships. This is determination of tax not paid, short paid, erroneously refunded, input tax paid, wrongly availed or utilized for any reason pertaining to the financial year 24-25 onwards. What does this mean? Assessment is financial year wise, my lords.
No, 74.
Lordships. 23-24. Lordships, onward. Yes, ma'am. No, why I'm saying this is, why it is then financial year wise? Why it could not say period? The point that is falling for my lord's kind consideration is this.
Finance Act 2004.
No, my lords, this was introduced earlier to be effective from. And show your lordships.
74A inserted by section 138 of the Finance Act 2024.
Lordships.
Then
Effective from.
effective from 1/11/2024.
Lordships. No, then, my lords, then from 1/11 they had changed it to the financial year. Because this was the case that assessments have to be done financial year wise. Lordships. That's the reason, my lords. 74A. Giving a clear answer.
Now tell me that
Lordships. Lordship, may I just then point out to your lordships, the high courts have taken a view, examined this scheme of the act. Lordship, may kindly have just one judgment, my lords. Just one judgment of the Karnataka High Court. It's the latest judgment, my lords, because it reproduces in extensive
which one?
page 18 of this compilation to my lords, which I handed over today. Page 18, your lordships have. Lordships. Here your lordships may kindly come to para 5. There Ambika, Mathur, all have been noted, my lords. They have considered, my lords. Para 7 at page 20, my lords. The following issues arise for consideration of present petition. Whether clubbing, consolidation, bunching, combining of multiple tax periods, financial years in a single composite show cause under 73-74 is permissible and valid in law. Whether the show cause notice dated so-and-so issued to the petitioner for the financial year from 1920 to 2024 under 74 warrants interference by this court in the present petition. Lordships may kindly then come to, they have reproduced the section, my lords. Kindly have page 22. Page 22, para 8.1 onwards. A conspectus of the provisions of the CGST-KGST Act will indicate that the said Act, in its very architecture and statutory framework, is designed around financial year specific assessment and every stage of the statutory process, that is registration, maintenance of accounts, filing of returns, reconciliation, determination of liability, adjudication, and limitation are all structured independently for each financial year. A consolidated show cause notice collapses this entire legislative framework, causing jurisdictional illegality. To appreciate this, one must examine the statutory design. Chapter 6 requires registration in a state from where supplies are made and imposes responsibilities on the registered person to maintain accounts under 35(1), which include production, inward supply, outward supply, stock, ITC availed, output tax, etc. These are necessarily year-specific because 36 requires retention for 72 months from the due date of the annual return for that year. Chapter 9 on return reinforces this annual structure. Section 37 outward supply and Section 39 monthly quarterly return govern the furnishing of returns for each tax period, and 44 requires furnishing of an annual return and reconciliation statement for every financial year. The annual return statutorily closes the year's tax position, and all subsequent proceedings must be tied to that financial year alone. The same year-wise discipline runs through Chapter 10 relating to payment of tax. Section 49 provides for machinery for payment of tax through electronic ledgers, defining tax dues and other dues as tax, interest, penalty, fee, etc. only for the period to which they relate. ITC utilization is linked to returns filed for each period, further affirming the year-bound nature of GST liability. Moving to Chapter 12, which deals with assessment, 59 contemplates self-assessment, requiring a return for each tax period. Even provisional assessment applies only where a value or rate cannot be determined for that specific period and not for a bundle of years. Scrutiny of returns, assessment of non-filers, assessment of unregistered persons are also period specific. Section 65 empowers the commissioner to conduct audit, but even this exceptional power can be exercised only for a financial year or a part thereof or multiples thereof, always distinctly, never in a consolidated manner, unless each year is separately examined. Chapter 15, the determination provisions make financial year foundation even more explicit. 73.2 and 74.2 require a show cause to be issued within the limitation applicable for that financial year. And 73.10 and 74.10 mandate that the final order must be passed within 3 years or 5 years respectively from the due date of the annual return for the relevant financial year. The provisions make it clear that the starting point for limitation is the due date of the annual return for the specific financial year when actually filed or when it should have been filed, or in cases of erroneous refund, the date of such refund. The ending point is a fixed 3-year or a 5-year period window tied exclusively to that financial year. Show cause must be necessarily issued at least 3 months before the expiry of limitation for that year. These timelines are meticulously carved in the statute and cannot be diluted by clubbing multiple financial years into a single notice. An even clearer expression of this intent is found with the insertion of 74A, dated 6th August 24, effective from 1/11/24, which begins with the word pertaining to the financial year 24-25 onwards. The legislature has expressly tied the determination of tax not paid, short paid to a single financial year, confirming that GST assessments are intrinsically financially year specific. The introduction of 74A does not change the earlier law. It clarifies the legislative scheme which existed. It is also significant to note that a composite notice for multiple financial years enables the department to blur the statutory distinction between 73 and 74. If certain years fall under 73, but the entire block is treated under 74, the authority artificially extends limitation and bypasses mandatory statutory constraint. And if such a course is permitted, it clearly tantamounts to a colorable exercise of power which is impermissible in law. Further, ITC entitlement under 16.4 itself is year bound. Each invoice pertains to a particular financial year and credit can be availed for a statutory cutoff for that year. ITC for 1920 cannot be mixed with ITC for 21-22 or any year later. 16.4. 16.4 was also not cited before the Delhi High Court. Kindly have 16.4. Therefore, a consolidated allegation for wrong ITC for 5 years is conceptually flawed because ITC entitlement is actually frozen for one financial year at a time. In fact, a consolidated notice creates a substantive prejudice. Lordships. Each financial year involves different turnover, ITC positions, contracts, amendments in law, accounting treatment, reconciliations under 37, 38, 39, 44. The assessee is entitled to give year-wise explanations, year-wise reconciliations, year-wise legal defenses. A single notice covering 5 years deprives the assessee of this opportunity and violates natural justice. Lordship, then they reproduce from Vermax, from Bangalore Turf Club. Lordships.
How can the principle of natural justice be considered on something which has not happened yet?
I'm not on natural justice, my lord. I'm on
Has
Lordships.
been observed.
Lordships.
It will violate the principle of natural justice, which is, yes, it may be in a particular case. You are not in a position to understand in view of the language used in there. Yes, it is a case for that particular petitioner or the person necessarily concerned. But in my opinion, with due respect, I kindly come to this particular paragraph, page 29, paragraph 20, where which High Court, I think the Madras High Court was dealing with this aspect.
Lordships.
I come to the paragraph 12, paragraph 11.
Page, Lordships, are referring to which page?
Quotation of paragraph, judgment passed by the Madras High Court,
Lordships.
29 of the compilation.
29, Lordships.
It's a part of paragraph number
20.
when they come to paragraph 11.
11, my lords.
Yes.
73.3, 74.3 of the GST Act refers to issuance of a statement for subsequent tax periods containing the details of the tax liabilities pertaining to the respective tax periods. If a notice under 731, 74.1 of the GST is issued for any particular tax period, a statement shall be issued in terms of 73.3, 74.3 for subsequent months, and the said statement shall be deemed to be a notice issued under 731, 74.1.
Now let us see one thing.
Lord.
73 conceptually, where a notice has been issued for any period of the subsection 1. The proper officer may serve a statement containing the page 20. Now you see the way,
Lordships,
the interesting language of 74, 73-4,
Lordships,
and we do to 74-4.
Lordships.
70, the moment it is a notice under 73-1, you are again to give the state.
Yes, my lords.
Okay. For the remaining 2 years.
Yes, yes, your
At
lordship.
best.
Your lordship.
And these 2 years, again, by operation of law,
Lordship.
by 74-4,
Four.
it will become again a notice for the subsequent years, 73-1.
71,
Three.
lordships.
But interesting in 74-4,
Yes, my
it
lords.
becomes a year under 73-1.
73-1, except these conditions, my lords. Therefore, there can be a case, my
But
lords.
therefore, tell me one thing. This also in interesting aspect, it shows that it is for the as you say, for the subsequent period.
Lordships.
So it is only for the subsequent period. So if you issue a notice on 2017-18,
Lordship.
you have to mention about the statement in respect to 2018, 19, 20, 21.
Lordships.
You have to mention it.
Yes, my lords. Your lordship.
Now, how do you take care of that in that notice that if it comes under, it's a case of fraud there also, how do you issue it? That is what has been explained in the paragraph 11. Have a look
11
again.
million. Yes, your lordships are right. Your lordships are
Have
right.
a look at paragraph 11.
Paragraph 11 left. Outside or that. 73.3, 74.3 refers to issuance of a statement for subsequent tax periods containing the details of tax liabilities for their respective tax periods. If a notice under 731, 74.1 is issued for any particular tax period, a statement shall be issued in terms of 73.3, 74.3 for subsequent months, and the said statement shall be deemed to be a notice under 73.1 and 74.1.
But why does it say here in respect of terms of for the subsequent months? Where does the
No, this is subsequent period. It's language is period, not months. Subsequent periods,
period will be subsequent tax periods?
tax periods. Period will
And
be
subsequent tax
period.
periods will
Period
be
is financial year.
finance.
Financial year or any period within the financial year. So lordships, there can be a case where they can issue a notice to me, say for March, April, May, June, July, August, there can be another notice.
Now tell me, if by virtue of 73.1
Lordships.
and the notice containing a statement of 73.3, it is by deemingly, it becomes a notice under 73.1 and view of 73.4.
3-4 lordships.
Isn't it a consolidated statement for everybody? Because it is by the deeming provision, it
Lordship.
becomes 73.1.
Yes, your lordships are right. Therefore, they have not, otherwise there was no need for these sections. Why statement is required? Lordship, I ask myself a question. Why there is a need for 733 and 4? The need is this only because this is annual. Statements will be issued for every year. I need not repeat it. I, the revenue, I, the tax officer, have to issue statements for every year, whether it is under 74.1 or 731. Reason was this only precisely that once I issue a notice, there is no consolidation. There has to be a statement for each period. There has to be a notice for each period. Though they may be containing the same grounds as the earlier.
Once a notice is issued under 73.1,
Lordship.
for the year 2020-21,
Lordship, 2021.
and they put for the other two periods, 2022-23 and 2023-24,
24. Lordship.
in the state. Is already a notice under 73.1 for 2021-22. For the year 2022, 23 and 23, immediately by 74.1, 73.1, or 4, it becomes a notice.
Lordships.
It is required for issuance of a notice.
Not required, my lords. That's my submission.
So therefore, that is not required.
No, my submission is this. Why 2, why 3 and 4 were there? Reason was this only, that there has to be a notice for each financial year. And by virtue of, by the operation of law, these will be treated as a notice under 731. Let us read only 731, independent of 4 and 5, my lords. Can they issue a notice to me or no? Then, my lords, in that event, my lords, your lordships would have been right to say that no, there has to be one notice only, because there cannot be multiple notice for multiple periods. 3 and 4 support that. That for every year there has to be a notice. That statement is a notice. That statement that they issue under 73.3 or 74.3 is a notice. It's a notice. Why that was required? And why 73.4 and 74.4 was required?
But if it comes under 74,
Lordships.
there has to be have those 3-4 elements for coming under 74.
Lordships.
Fraud, misrepresentation, and
Lordship, that's what, my lord. That's why the legislature provides for an exception. Because exception is a question of fact, not a question of law. Whether they have the grounds for invoking fraud for that period also or not is a question of fact. My limited submission is whether they do 73 or 74, they have to do it for each year. There has to be one notice for 1 year, one notice for 1 year. And that is what is.
Therefore, my
Lordship,
question is,
Lordship.
how do you issue a notice, second notice? Because it is by operation of law, it's a deemed notice.
Under 74.4,
So it is a deemed notice.
deemed notice under 73.1. That statement,
No. It will be a deemed notice for 73.1.
Lordships,
But for the purpose of having, it's a case of fraud.
Lordship.
But you are required to give a statement for the other years.
Lordship,
The subsequent years, you have to give the statement. Now, if you don't save it,
Lordship.
by issuing the consolidated notice, it will automatically be a 73.1.
Will not, my lords, kindly have 4.
How do you give that notice? Tell me. How do you give a notice of fraud?
Under 74.3. 74.3. Lordship, it's a notice under 74.3. So, for example, let me put it very simply, my lords. 18-19, 17-18, 74.1. One notice, no problem. For 18-19, it will be under 74.3 statement. Your lordships are putting it to me, and rightly so. Your lordships are rightly so, that by virtue of 74.4, it goes to 73.1. So whether they will write that it is a notice under 73.1 or 74.1, can they issue, suppose they find that there is a fraud in 17-18 also, 18-19 also. Let us assume they want to invoke fraud for both. Can they invoke or not? Answer is yes, they can. Because 74.4 says that it will be 73.1 subject to the condition that there is no fraud. If there is fraud, 74.4 doesn't come into operation, my lords.
But therefore,
Lordships.
my question is,
Lordships.
wouldn't be a deemed notice under 74.1?
It will be, my lords.
So you don't need to issue a notice for the subsequent years if you don't mention it, because it becomes in view of 74.3 and 74.4, you are required to put a statement.
Statement for that period.
And the moment you put the statement,
That is a notice.
it will be a deem coming under 74.3. 73.1.
Lordships.
It will be a notice under 73.1 unless you save it. So you have to save it under 74.1 by putting everything.
No, my lords. They have to save it by putting under 74.1 the first year.
Show me the form to be issued for this purpose, which is the form required under 73.
No, that's what the form is, that every financial year. Lordship, may kindly see.
No, understood. But where
Tax period. Lordship, may kindly see the form again. DRC 01. Lordship, may again have the form. What I'm saying is supported by the form, Lord, clearly. This is how the states have been doing it also, my lords.
state, they don't know anything. You, Mr. Council, you have to look into the states, means they have.
449, Lordship, may
I
kindly.
don't say about other states, our state is not. Yeah. Now, where is the statement for the subsequent year? Subsequent years, where is the statement?
Lordship, may just.
You are Mr. Raichandani.
Lordships.
I'll just excuse myself for 5 minutes.
Lordship. My apologies. My apologies. Lordship. Lordship.
Show me something on an interpretation given by the courts as regards 74.3 and 74.4.
Lordship.
think, let's see how Ambika treats it.
Lords may have Ambika.
Ambika, how does they treat the 73?
That is Manoj at page 70.
Eight.
Page 70 of the compilation which I handed over on the first occasion, Manoj. Page 7. Lords may kindly come to page 81. With great respect, Ambika went more on facts, Manoj. Lords may kindly have page 81. Kindly have Ambika, page 81. Lords have para 43. Lords. Insofar as the issue of consult notice for various financial years is concerned, a perusal of 74 itself could show that at least insofar as fraudulently availed or utilized ITC is concerned, the language used in 74.3 and 74.4 is for any period and for such periods respectively. This contemplates that a notice can be issued for a period which could be more than financial year. Similar is the language of 73. Then they reproduce the section. Then Manoj, para 45. Thus 74.3, 74.4, 733, 734.
I'm not on that.
No, Manoj, they have not interpreted. No. What,
I one day.
what's falling from your lordship is not there.
Was 74.4.
Lordships.
It is by deeming provision becomes the 73.1.
Lordships.
The moment you put a statement under 74.3,
Lordships.
unless you save it, isn't it compulsorily necessary to have a consolidated here? You
Lordships.
see, a question of being violation of Article 14 or principles of natural justice will come under 14 on unfairness or unreasonableness on that. That is another aspect by which you may have to challenge it.
Lordships.
I am of the prima facie opinion, which I think it is my duty to inform it to you, that unless you don't have a consolidated notice, you would not be able to save it from 73.1. What do you mean?
Lordship. Lordship may kindly have not 74.
2022, 23,
That is fine.
that is okay. You don't need to mention about the subsequent period. But otherwise, the moment you put the statement out there for the subsequent, you immediately go to 73. So therefore,
You just
see
say,
a new angle by which we are looking.
certainly, Lord, certainly. Your lordships have made a very valid point. I'm making an endeavor to satisfy your lordship an answer. Lordship may have 74.3 again. (74.1). Lordships have.
Yeah.
It says, he shall serve notice. Lordships have that. He shall serve notice. Because I'm making a submission as an endeavor. If something turns on this, Manoj. 74.2 says proper officer shall issue the notice. Mandatory. Whereas 3 says, where a notice has been, proper officer may. He may. He may or may not. He may or may not. When he chooses to, he exercises the option, then only 74.3 and 74.4 will kick in.
So the moment he does not,
Lordships.
then he has to issue a question.
Fresh notice. That's my submission, my lords. That's precisely my submission. That the scheme requires you to give me one notice for 1 year. I pass order, no difficulty. you can have another notice under 74.1 itself. You don't need to go to 74.3. It is may. And kindly see again 10 says shall, 9 says shall. All these say, only 3 says may. So 74.3 and 74.4 will kick in only when he chooses to. He exercises his option. It is at his option. It's not mandatory for him to issue that statement. If he issues that statement,
So, may serve a statement containing the details of tax not paid during the paid out utilized for such periods other than those covered under subsection 1. On the person when now kindly see 4.
Lordship.
The service of the statement under subsection 3 shall be into the service of notice under subsection 1 or section 73.
Lordship.
So that means it is already a notice
It's already a notice
under 73.
under 71.
Subject to the condition that the grounds relied upon in the statement. So in the statement, there has to be grounds relied upon,
Grounds relied upon as in the first notice.
except the ground of fraud or any misfill so and so or to the evade tax for the period other than covered under subsection 1 are the same as mentioned in the review. DRC 02. Here also, PC 74.3. It also mentions the
Period. Yes.
your submission is DRC 01 only mentions period. And financial year,
Both.
but if you see for subsequent years, if we go as per 74.3, what we are saying,
Lordship.
will come, you are issuing notice for 74, 17, 18, but for subsequent years, you are given. Then tell me, how do you take care of this? In DRC 02 also mention about period,
Yes, my lords.
doesn't mention periods.
It says period only. For subsequent also there has to be period. It cannot be multiple financial years.
Why not?
It says period, financial year.
72, 3 say,
Lordships.
72. It was
For such periods other than those covered under one.
so it will be subsequent. That means you mean to say that for 17, 18, it can only give for 18, 19.
No, my lords. It can be done for 18, 19, 19, 20.
Therefore,
Period here means, my lords.
so therefore,
Period here means tax period. Lords.
therefore, that statement which is submitted under 74B
Lordships.
is to be given in terms of rule 142.
Lordships. Rule 140.
And this is in DRC 02.
Lordship. DRC.
DRC 02 also mentions about the experience,
Lordships.
not period.
No, my lords.
Therefore, so you mean to say the moment the statement is given under 74.3, it will only come under 74.1. 73.1.
731, my lords. Has to be, my lords, because with knowledge suppression ends, my lords. If I know that you have suppressed for a particular period and I already issued a notice to you, for subsequent periods, I have to issue a statement. Tax demand can be there. There is no question. Tax demand can be there. For subsequent periods, I have to issue a statement, and that statement also has to be for each financial year. For 18, 19, 19, 20, 20, 21. This is precisely the reason why they are usurping this. By issuing a consolidated notice, they are trying to cover periods which were under 73 in 74. This is precisely what is being done. Periods which were covered otherwise under 73 are being thought to be covered, and time limit has been over.
Let us take an example where for the last 4 years or 5 years, there has been a constant action on the part of the mortgage business available, SSC concerned for defrauding the revenue.
Lordship.
Question. So you mean to say the moment I have for 2017-18 and I put the statement and it is not saved, if at the moment I put the same statement under 74.3, it will automatically go to 73.1.
Except if there is no fraud, my lord, that they can invoke. No, my lords, that's
So therefore, you have to serve your submission would be that in a case under 74.1, where you want to have it for multiple years,
lordships.
there are various years for which you want to initiate the proceedings under 74, then you cannot give a stake.
No, my lords, my submission is this. 73.3, 74.3 and 74.4 are provided for that purpose only. Precisely for that purpose only. They don't say that it will go out of suppression 74. what this scheme of the act requires the assessing officer or the adjudicating authority to do is this: issue for each year. Your lordships put me a question for 17, 18, 74 is there, no problem. That will be adjudicated as per support. What happens to 18, 19, 19, 20, 20, 21? Precisely there, the section says proper officer may. He may choose to issue a statement. He may not choose to issue a statement. He can issue a 74-1 notice. There is no bar, my lords. There is no bar under 74-1. That 74-1 cannot be invoked for 18, 19, 19, 20 also. So he can issue a notice to me. But that notice has to be an annual notice, a financial year notice. Precisely why? Because once, suppose, my lords, in 2021 I came to know and I issued for 4 years under 74-1. Subsequently, I may choose. It doesn't say shall. I may choose to issue a statement under 74-3, which will, by deeming fiction by 74-4, be treated as a notice under 73-1. Except
you are outside the ambit of penny.
Outside the ambit of penny. This is what the legislature thought is, and not to give a handle to the revenue precisely where 73 is there. They want to invoke 74 because they want to cover the limitation. 73 limitation is over, my lords. They are aware. Therefore, they are invoking 74 to usurp that jurisdiction, 73 jurisdiction. Precisely why the legislature also wanted them to issue a financial year wise notice, whether under 73 or 74. Otherwise, language is identical, my lord, except for fraud. Why 73 requires, my lords, periodical notice? Let us forget fraud for a minute. Why there is a section called 73.3? They can issue under 73.1 itself. Why there is a need for 73.3? Why there is a need for 734? Kindly have that. There is no suppression there. There is absolutely no suppression, fraud, etc. there, my lords.
Right.
Under 73. Why there is a need for 73.3 and 73.4? And why there is a deeming fiction under 73.4 saying that will be treated as a notice under 73.1?
No, if you don't give the notice,
Lordships.
you don't put the statement, there won't be the deeming provision will not apply.
Will not apply. That's my precise submission, my lords. That this was provided so as to, you don't need to repeat everything. Subsequently, my lords, suppose they say there is a classification issue, forget in input tax credit, etc. There's a valuation issue. There's a classification issue. There's a valuation issue. For every year, I will issue a notice to you. Subsequently, I will only issue a statement. I will not labor again and again by issuing separate notices. I will issue a statement, simple statement in that form, DRC 02. That statement, I will say, refer to that show cause. That's it. Refer to that show cause. This statement will be deemed to be a notice under 731. That means every year there is a notice. Every year there is a notice. Every year there is an adjudication. And this has to be read with 7310 and 7410 marks. Because the assessment says the adjudication is related to that financial year. And it says the financial year.
Assessment that 74.3 or 74.9 or 73.9 does not say about the financial year.
Kindly see 10 minutes.
10 is different. 10 is for the limitation.
Limitation.
Limitation is different.
No, minutes. Qua the financial year. When it says the, I'll show there are several sections, if your lordships permit me, where it talks about a financial year. Whereas 73, 74 both use the term the financial year. The means that alone. So it has to be one. It cannot be multiple. It cannot be plural.
No, 73.9 or 74.9 does not say anything about that financial.
It says, kindly see 73.9 or 74.9. Pass an order. A1. Proper officer shall determine the amount of tax, interest and penalty due from such person and issue an order. An order for what? Now read 7310. Because it cannot be read independently. Kindly see 9 and 10. Proper officer shall issue the order under 9 within a period of 5 years from the due date of furnishing of annual return for the financial year to which, Lordship may kindly see, the financial year to which the tax not paid relates. To which the tax paid not relates. So there has to be that limitation, Lordship, right? Lordship, 3 years or 5 years has to be calculated from that financial year to which the tax pertains to. There has to be a order for that financial year. Therefore, my submission is there has to be one notice for each financial year, one order for each financial year. They can do it even today. Then all the courts have granted liberty, my lord. It's not a case, my lord. Every court has said you do it today. Wherever all these courts have allowed the petitions, my lord, saying that you cannot do this, they have said, please do it just now. Kindly see. Kindly see that, my lords. Kindly have that. The respondents are at liberty to initiate appropriate proceedings in accordance with law. An issue,
I have also passed many orders exactly.
lordships.
There were no proper notices, they had only issued the summary.
Lordships. They can do it even today, my lords. They can do it. Lordships.
The limitations have been pending.
Lordships.
Be excluded by completing the. That is okay. That is not the issue of the time of concern is can we have this particular interpretation say that it has to be separate. Anyway, we do want to any other issue apart from this?
Manoj, apart from this, there is one other issue under 122 1A. That is squarely covered by the Supreme Court judgment in my favor. Manoj, that is under 122 1A, penalty can be imposed on me. That's an individual. I am the individual, Manoj. I am the individual. Can penalty be imposed on me under 122 1A? It can be under 122 3. For that is provided for anybody who is aiding, abetting, etc. Individuals are there. That can be, they can impose penalty that I'll have to fight whether penalty ought to be imposed or not is a question. In law, whether 122 1A can be invoked against. That has been decided. That the Honorable Supreme Court, the Bombay High Court took a view, Manots, and the Supreme Court affirmed it, Manots. I'm an employee. 122 capital 1A, 1 capital A. Lordships. Now, this penalty can be imposed on the taxpayer, the assessee. The company who retains the benefit, penalty can be imposed, certainly. 122 1A cannot be invoked against the employee. 122 1A can be invoked against a person who has retained the benefit of tax, credit, etc. That is the taxpayer. That is the assessee, not the employee of that assessee. For that, 122 3 is there, my lords. For that, 122 3 is there.
So that is maximum is 25 now.
Lordship. That they can invoke. That they can be imposed, my lords.
And if it is a proprietorship firm, then the person.
Yes, my lords.
If it is a company, obviously it cannot be done. It has to be the company.
My lords, even any assessee, basically, what your lordships have held, my lords, the judgment of the Bombay High Court has held, they in fact quashed the notice, my lords, and the Apex Court affirmed it, my lords. They said, they interpreted this section saying that this has to be the assessee, the taxpayer, and not the employee or the directors or etc. my lords of the company. This is the Apex Court judgment against this judgment of the Bombay High Court. Honorable Justice Pardiwala has dismissed the appeal filed by the revenue lords.
Law is kept open.
Lordships. Lordships. Milord's penalty on Milord's penalty of 100 crores on employed Milords. When the law provides for 25,000, that they can impose. That they can impose on the company, there is no difficulty, or on the firm, or on the assessee. But on the individual Milords, they are taking away my right of appeal. If they impose penalty of 50,000 Milords, at least I can file appeal, I can prove my innocence. If they impose penalty of 50, 100 crores Milords, how will I, Milords, if it's effectively rendering me without remedy Milords, that's what the High Court is.
Where is the order here? In this case?
Milords, in this case, Milords, there are two individuals. One was the assessee Milords, where this consolidated notice point is there.
In this case, which we have quickly cited in Tata projects.
No, Milords, this is, there is no, this consolidated notice point is there in Tata projects.
In which case you are referring to?
Milords, there. Writ petition 24 or 26 Milords, listed on your Lordship's board today.
Yeah, what you have challenged is section. Have not filed an appeal against this one.
Your Lordship is referring to writ petition.
Tata projects,
Shut up. No, we have filed an appeal.
where is that?
Appellate order. We are against, before your Lordship, against the appellate order. We are against the appellate order before your Lordship.
The only question is consolidated.
Consult notice, my lords, that is one. Second, your Lordship may kindly see. This was, my lord, this actually ITC mismatch in my, from the system they can see. You know, that's a reconciliation thing that they can examine. Commissioner appeal is not examined because they said you did not place all this before the original authority. I will not look into this. They have to only examine that.
Mr. Rajchandra, that day I passed one judgment in Kohima bench. There was a mismatch with certain amounts as per the GSTR one, with GSTR 3B. So Rule 88C has not been properly given effect,
Lordship.
but I allowed it to the extent taking into account some judgments which have been passed. These Bombay High Court committed correction. That matter went to the Supreme Court.
Lordship, Star Engineers Bombay High Court judgment. The Lordship is referring to Star Engineers Bombay High Court judgment.
I think so.
The rectification was allowed. I only argued that matter.
Okay. So the matter went there to the
Supreme Court, my lords.
Supreme Court said that we find the order to be just.
Lordships.
Matter came up whereby Bombay High Court permitted correction.
Correction.
Thereupon, I think Madras High Court also followed suit.
Lordships.
I said, okay, the correction you can be permitted. I, however, followed the very principle of 88C and said that, okay, you make this correct and show it that if this is some apparent mistake out there, which is apparent from the returns out there, obviously that can be corrected.
Corrected.
Because you cannot charge anything to that effect. Yes, there was a mistake. If you see, it makes you to correct within a particular period of time. Then also, Bombay High Court and Supreme Court also has said that you can correct it if there was an apparent, but you have to satisfy that. That's what my answer was passed.
Lordships. Lordships. That,
Okay.
my lords, that they can examine even today. That part, my lords. It's a pure that thing. And they are invoking 74 for that, my lords. 74 for that. That they can see on their system, my lords. There are errors. Errors are there on the system. We said that we can rectify it, my lords. For that, they cannot be
But that
70.
is for Tata projects.
That is for Tata projects.
That is the only issue
That's the only issue.
on which the appeal was dismissed.
My lordship, the appeal was rejected by the authority.
On the ground?
Manoj, one was you have not raised these before the original authority.
Okay.
Yes. Second, Manoj, this was that this mismatch cannot be rectified.
So it will be a case of, if there is a mismatch, whether it is a case of suppression.
Cannot be Manoj. Manoj, if you
That is on another line by which one has to go into, that is the Telangana one judgment.
lordships, that exactly what fell from a lords in the morning, the Telangana High Court judgment.
Telangana judgment clearly says that how you have to.
How you have to read 74, your lordships.
You have the Telangana judgment.
I'll get. I just circulate for lordship.
No, there are various, you are challenging the issuance of notice. Why so late?
Manoj, I had challenged it before them also.
Understood, but why so late? Yeah.
Manoj, I had challenged before the authority also.
When they don't have the jurisdiction.
Correct.
You have submitted yourself to the jurisdiction.
Manoj, I have not, I have raised this contention. That also appellate authority says you're raising it. That appellate authority says it's covered by that single judge of the Kerala High Court. At that time, not the single judge of the Kerala High Court taken a view, saying that it can be done. So he has followed that. But that was subsequently reversed by the division bench. That view was subsequently reversed by the division bench. That is therefore we have raised that contention. On merits, they can examine even today, Manoj.
Yes. And
So the issues of update notices already been decided by your lordship in the schedule.
right. Just first clarify. First hear him.
Paragraph 11. So far as crossing of one composite order, it varies with 2054, 2 financial years, and for submission by amount to section to section 74 pay. From Assam GST Act 2017. In my opinion, of the whole, the state better within the as much as the authority contract and the jurisdiction.
In fact, this order may help him.
No, can you not, they preferred appeal, they come, they preferred appeal. The section 112, further appeal is.
The tribunal is there.
Yes, sir.
Good.
Yes, sir. Yes. So the 1st of January, lots of it functioning.
With the notification, it will help me in getting rid of a lot of GST matters.
It is functioning, but I have this instruction from the.
Anyway, tell me, what do you say about this composite? How do you take care of 74 P and 44?
Delhi High Court in case of Vika, discuss all these points. Appeal was preferred to Supreme Court, although it was withdrawn by the petitioner in another case.
I read it. That I have written there.
After calling back to appeal.
Referring to
Yes. Paragraph 43.
my question is there. See, Delhi High Court looked into the question is that 73, 73, there is a mention of other things. How the Delhi High Court? Now, In respect to 73 or 73 again. Three, three, three. As well as 74 3. Yes, sir. The learned counsel submits. Petitioner submits. That there is a requirement to mention about such periods in fluid, taking into account that, just for example, in a case like here, where 2017 is the picture, when you are to issue a statement, you are to mention about the subsequent period or periods. Therefore, the word used is such periods. That for 2017, but you are giving for the other three periods. 18, 19, 19, 20, 21, 22, 22, 23. And therefore, has to mention about the further period, because the moment you issue the note statement under the further periods, you don't need to issue a notice under 73.1. You deem that it could be a notice under 73.1. Delhi High Court had assumed, or which is seen from Ambika or even in judgment, at paragraph number 45, only on the basis of further periods. And therefore, if it is further periods, is a necessity to have it for further periods, because you don't need to issue a notice under 73.1. It automatically be a notice under 73.1 for the remaining periods. The learned counsel, however, submits that in the case under 74.1, because 73.1 there is no problem. I don't think 73.1 you will have a problem, because of the fact it will again become 73.1.
71 only.
You don't need. But if it is a case under 74.1, the moment you give a statement, which you may or may not give, it would automatically be a notice under 73.1. So he therefore submits that the concept of consolidated, in fact, Mr. Raichanan, if I may just put it in this manner, you may just think about it.
Lordships.
It is not the concept of a consolidated notice for many years. It is a case where the moment you issue a notice under 73.1, 74.1, and a statement is being put, it would be an in notice for the consolidated year, subsequent year, the consolidated notice for the subsequent year under 73.1.
70.
So the concept of a consolidated notice may not be there, but it is not required. If we read both 73.3 and 73.4 with 74.3 and 74. But in the case, if it falls under 74.1, 74, and you don't give that statement, you have to issue individual notices.
Lordships. Lordships. I'm obliged.
That would be a better way. It
Lordships,
may not be a case of consolidated, because it is not required. It is by deeming for fiction, it becomes so and so.
I'm
So
obliged.
therefore, if you have to, the moment you give that statement under DRC 02, it will become 73. And if you don't give that notice statement, that means 73.3 is not there. Without 73.3, 74.3 is not there. Without 74.3, you cannot have 74.4.
Lordships.
And therefore, you have to give it. So
70.
you have to see the 73.3 and the 74.3 and 74.4 is not there. Then how do you think?
Agree.
I think we rephrase your submission in that manner. It would be better.
Lordships. I quite see. Lordships have paraphrased it beautifully, my lords. Yes.
That would be then would be a difference. The moment, because otherwise it's not a question of consolidation. It would become a 73.1. automatic. The moment you put that statement. But if you don't put the statement under 74.3, then in that case, 74.3 does not apply. 74.4 does not. If 73.4.3 or 74.4 does not apply, then how do you apply Delhi High Court judgment? Which basis on the entire edifice of its judgment is on 74.3 and 74.4. It's an interesting development
Certainly. The lords are beautifully put.
because Delhi High Court looked into only on that.
Only that.
And I think if we can have it in that manner now, in absence of 74.3 and 74.4, how do you say that whether it is required every year or
Lordships.
quite some time to address your message? This content. Look into that. Find out that I think if we make it, let us not go into that consummated notice.
Lords,
Not
I quite see what from the lords. Your lords are right also. Absolutely. Let us ignore that and see.
because it becomes a notice.
Notice, lordships are
Under
right.
73.
Lordships are right.
And if the moment you don't give a notice,
Statement.
even in 73 also,
73
you
also.
don't give a statement. 73.3, can't go to 73.4.
Lordships.
So therefore, for the remaining period, you are not initiating any proceedings under 73.1.
Lordships.
When?
Lunch ke baad? Lunch you have lunch. My learned friend has lunch, he can study.
Because the judgment which I refer to, I say, see, there was an issue of the why they were going. Now, if it is a case of one order, the problem is, I say that, okay, why should I interfere under 226? It can be a one order also. You can very well raise that under the statutory limit. Yes, that is why this was the order. That it is such a violation, I thought that. But would that be a precedent taking into account this omitting 73.4, 74.3 and 74.4? Or 73.4 and 73.3? Can you have that into? Or is it actually a case of consolidated?
Lordships.
You may very well argue. Yes. Maybe because of that fact that I have not given the statement. Yes, that I'm not given the statement. I have to tell you. If he has a problem with that notice, not being able to understand, he can very well raise that dispute somewhere. That is another. That is another. So therefore, what bars, because 74.10, into my council says about 74.10 and 73.10, says about the financial bill. I have some difficulty on that, except in taking impact on 73.9 and 72.9 is the power which has been given to us now. But only that you look into this. That's it. Yes, Mr. Rachandli, when can we again have the pleasure of hearing you?
I mean, my lords, lordships. It's my pleasure, my lords, to assist your lordships.
Yes, Mr. DJ Das, what do you want to say? Prejudice, no prejudice, what, you see, a notice can be a question of prejudice. But this is for the notice concern, for the petition. But we can't say the proposition of law that it would cause a prejudice prior to it, unless you challenge the very provision to be violation of Article 14. So while interpreting a provision, we don't decide on the basis that this provision is in violation of Article. It has to be for a person concerned who may be impacted because of that. For that, you may have to challenge the provision in there. That is not on that. So therefore, and as regards Mr. Yoshimi, have a look at my judgment which I did.
And also, I'll just have a look at that judgment, my lords.
That
If it covers me, it assists me, my lord, then if it covers me, my lords, then I'll be through.
because there was a mismatch pertaining to the filing of return under GST 3B with GST R1
Lord.
regarding the outward supplies and the inward PB, the final returns. Now, there in the GST outward supplies, you have to mention about the what do you call the credit notes and all these things are required to be mentioned. And apart from that, you are also to required to mention about the outward supplies. Now, while making the outside supply, they have put the interest at 18%, the tax at 18%. But actually, the invoice was at 12%. So when it was made at the GST or 3D, so they have put it at 12%. Now, taking into account the explanation which was inserted recently, 2022,
Lordships. 239.
7512,
12, yes.
they say that this would be a self-assessed.
Self.
And thereby it was taken, that was the amount and as such penalty and all these things will. Then whether, first of all, I say that when an amount of tax is to be imposed, is the legislature who has to fix or the state who has to fix it. When it puts 12% or 18%, that matter, doesn't matter. It matters on what is the impost. If the impost is 12%, 12%, if he has 12, if GSTR 3B has 12%, but it is really 18%, he has to pay it. But then also I then draw you the analogy which is taking into account section 57 as well as the corresponding rule. And also although 88C has not come in, but taking into those judgments, I said that this can be very well corrected. We can very well show it to them. And if the authority is satisfied, they may correct. They allow them to correct the GST at 3B or 1, whichever, they can very well correct. Although 57 says that you have a particular window.
Time limit.
That window. But that window also, that is what the Supreme Court at the Bombay High Court says that although there might be a lot of mistakes, the words used by the Supreme Court is bound to have mistakes.
Mistakes, Lordships. Yes, ma'am. In fact, my lord, this is Khanna pointed out saying that the CBIC should issue guidelines that if there are such issues which are inadvertent or which may be a mistake either on part of the assessee or the levy, has to be corrected. You cannot be technical about these things that just because there is mismatch, there is a short payment or a short.
No, in fact, the government also, there was a recommendation by the GST
Lordships.
Council on this aspect. Then the matter went to the rule has been made, rule 88C. But the problem is, what is the amount at which this correction is to be given? Because there has to be a notice on the 88C.
Lordships.
There has to be a notice in a particular form asking him to make the correction and asking him the explanation. If he does not provide an explanation, then you issue the 07, DRC 07. So that is there, but only problem is the government does not fix the rate at which when it is the amount. That is why it has, although the section has rule has become operational, but it is ineffective. Because that might help you.
I'll get a copy of that judgment. This one.
The senior counsel.
Not yet, that's
With petitioners in Just kindly give the numbers where it is appearing.
Lordship, I'll get to them.
You are appearing for? One for the petition. Anybody else? Arguments on behalf of the who's appearing. Where will- Here. That we require some time for if you wanted. Yes, Mr. Rajat.
20. 28th is fine, Manoj. 28th,
28 5.
28th April.
Something.
Or Manoj, I'm just making a submission because we don't have May vacations here. If there is vacation, then I can come anytime.
Wherever it's convenient.
Because this will be the last week for the Bombay and the Gujarat and the Karnataka High Courts. April, Manoj. Any day in May, Manoj.
Okay.
Those courts will shut, Manoj. Then I'll be at your lordships.
Let's have it on 5th of May. 5th of May.
Can it be 12th, Manoj? My apology. 5th, I may have some personal difficulty, Manoj. My apology.
12th of May. At the top of it. Doing it as part of it. Huh? You give your written argument.
Manoj, can it be on top on board itself?
Yes, we will. Will be shown as part of it.
Parted, Lordship. Lordship.
And came out of. These are compilations given, na?
Yes, Manoj. I have given two compilations, Manoj. The first one was this at the time of notice. The second one.
Compilation के लिए collect के रखी थी.
Lordship. Great.
The judgment and order dated so and so in WPC number so and so stands modified as herein under. The appellants herein are directed to forthwith regularize the services of the respondents herein against the sanctions we appointed. For the sake of clarity, we observe that the petitioner in so and so shall regularize against the sanction post of assistant horticulture specialist, and the petitioner in so and so shall be regularized against the sanction post of horticulture specialist. The petitioner of the respondents herein shall be the petitioner of the respondents herein shall be entitled to all consequential service benefit accruing from the date of the judgment passed by the learned single judge. Advertisement number so and so is interfered with only to the extent of filling up of the vacancy of one post of horticulture specialist in so far as serial number 2, vacancy number so and one post of assistant horticulture specialist at so and so. The remaining posts advertised in the advertisement are not interfered with. The process of regularization be completed within a period of 3 months from the date of the present judgment.
Obliged.
I think we can please. Yes,
Obliged.
disconnect.
Yes.
May I please, Lordship? Lordship, my lord, Yesterday, your lordship raised some questions regarding my detail this petition and to approach the appropriate other form. My lord, on that, I would like to admit that writ petition is maintainable because the order of the petitioner, who is in a comma space, does not fall under the definition of all this act. And that has been discussed in several judgment of the different high court. There are some judgment I would like to rely. And this judgment is, my lord, first one is 2020 Supreme Delhi 75. This is the judgment of the Delhi High Court. There are some other judgment of Madras High Court, Kerala High Court also. Lordship may kindly read this judgment first. Paragraph 9, the state bank has raised the maintainability with petition. The similar circumstances may not response were raised, whatever raised by your lordship yesterday.
You are not in coma. Comatose says is different. No, Mr. Counsel. That I have also held in one of my judgments.
My lord, my humble submission before your lordship. Lordship may
Comatose says is different. Where the court assumes the rule of a parentis parentis or there is a particular doctrine out there. This won't apply here.
my lord, if your lordship, my lord, constitute a commission to inquire about the status of health status of the patient, my lord.
Produce a medical document here. Medical document out here that he is in a state of coma. The coma is different. Coma, the court will take it over.
It is as like as coma, my lord, he
No.
cannot communicate, cannot, my lord, move himself, my lord. He cannot speak a word, my lord.
I have dealt with one judgment in the case of iron. I dealt with this very issue out here. Where there was this mother, was the question out there. Mother was in one of the mother space. She was a vegetable out there. So this is how I passed on. Nothing.
That is, my lord, I think, my lord, Him Singh's judgment, my lord, that is another judgment, my lord. The similar like situations, my lord, that is also caused by the relying on this judgment, my lord.
Comatose is different. Comatose is different. You have to bring a document to that effect. Comatose. Then obviously this court will take it.
Medical purpose.
Comatose is different. Comatose is the person has no sense. He's on ventilator or something to the effect. That is not the case now.
Because like with that situation, my lord.
No.
If your lordship, my
No,
lord,
no, no,
my
no.
humble submission before your lordship, if your lordship, my lord, consider the advocate commission also, my lord, to look up, my lord, to
That
see
is
the
not possible. Why should
health
I?
status of the petitioner.
Why should I? Not
In the otherwise, my lord, I have to submit the medical documents.
It is a dispute between you and that lady. What do you say, Mr. Baru?
Your Lordship, the prayer that is made by the petitioner,
Huh?
here, the prayer that is made by the petitioner is regarding the changing of the mobile phone number, Your Lordship. Registered mobile number of the bank account. And it can only be done at the request of the account holder. No any other person can make the request, Your Lordship.
Look into it
Then-
properly.
Lord,
Something.
he cannot,
Matters is different.
lordship, may
In
kindly,
fact, if you see the 1999 Act, see the 1999.
National Trust for Welfare of Persons.
Only see 99 Act. Here it's a different thing. Here a person can be appointed. Only see 99 Act. It says multiple disabilities. Means a combination of two or more disabilities that defined in section 2(1) of the Person with Equal Opportunities Act. Now 2(1) is what? 2(1) is given out here. Disability is blindness, low vision, leprosy, hearing impairment, locomotor disability, mental retardation, mental illness. All these things will come under this 99 Act.
for my humble submission, this definition also not covered the condition of the, my lord, father.
Why?
My lord, this health condition. And in fact, my lord, if we have to go to the, my lord, provisions of this act, I have to approach the, my lord, first for disability certificates. All this, my lord, procedure, it takes several times. It takes several times if I, my lord, approach the authority for a disable certificate. I have to first obtain the disable certificate. Then I have to, my lord, approach the authority.
So you want to make a shortcut?
In
by
that, my lord, in the sexual circumstances, in that case, the state bank, my lord, refused only two grounds, my lord. Only one is, my lord, persons, the account holder has to, my lord, authorize the person. There is no, my lord, capacity of the account holder to, my lord, authorize any person, including his daughter. And my lord, as part of power of attorney, if your lordship go through the affidavit filed by the bank authority, my lord. Lordship may kindly see, the bank authority itself, my lord, admitted in paragraph 9 of the affidavit in opposition. They have sent a person to ascertain the health condition of the father of the petitioner, account holder, paragraph 9, page 44.
In my judgment in Ayan Kumar Das, I've held. Therefore, a person in coma or in a comatose condition or in a vegetative state cannot be construed that such a person is physically challenged person or mentally challenged person as is understood under the various relevant statutes. So and so. Accordingly, the doctrine of parenthood assumes importance. The same doctrine of has originated in British law and all these things are mentioned. There I direct, mainly in the light of Eva, that the petitioner shall be treated and accepted as the guardian of so-and-so who is in visits. We have to do that. Produce some documents to that effect.
I'll produce it.
Well, after vacation,
After that.
at the request of Mr. D.K. Sharma, the learned counsel appearing on behalf of the petitioner. Matter stands adjourned. to produce medical documents of her father or of the petitioner's father by filing an additional affidavit. List this matter again on
Can you just after petition?
24th,
Fine.
on 24th of April 2026. In the meantime, the additional affidavit. was filed.
May I pray, my lord, one thing, my lord. The amount, as per the power of attorney, my lord, rent is, my lord, may be collected by the petitioner. And the amount that deposited by the rent, that is doing by the mother of the petitioner, who is a divorcee and remarried.
The council, I have to be
My
first,
lord,
no, Mr. Council, I have to be first satisfied for issuance of notice. I'm not yet satisfied.
Problem.
Fine. Order please 11 minute and direction please paragraph 7. It's 13 minutes with submitted.
Why are you aggrieved?
Till date, no action has been, but this copy mill order, no action has been.
What action?
Not
What action?
regarding mill settlement as per the.
No, no. It says, go ahead and make the settlement within 3 months.
Same has not been done yet.
Not done. Then
There will not, no Bakizai proceeding in fact initiated as per this direction.
where have you asked?
Paragraph 7.
No, where have you asked for initiation of Bakizai proceedings?
In that direction made this.
No, where is, have you asked for? Then kindly go initiate the Bakizai proceedings there with, within 3 months it has not been done. Where is it?
The authority has not,
No.
ADC has not initiated any process.
That is not the way. Go and approach them. Bakizai has to be done before the district commissioner or or you have to ask the deputy commissioner or the Bakizai officer to initiate Bakizai proceedings.
The proceeding, but since Milord on the on last occasion, Milord,
Huh?
on disposal date, Milord, one letter placed on 25/7/24, Milord. There is this settlement, this proposal made by the government.
No, what is the present status of the Bakizai proceedings?
So, no, I mean, nothing, Milord, don't know.
Have you visited?
Since Milord, that stages, they have not issued notice to us regarding to appear before their process.
No, have you approached the authorities? Why the Bakizai proceedings have not been initiated, the process? Because it was already initiated.
Milord, we're not aware, Milord.
Go there, find it out. Do you think that this court is going to find out all these things? No case.
Milord, that may be anything, Milord.
Huh?
That the concept be person and get pending, Milord.
No.
Okay, otherwise,
It has to be on the first day notice or no notice or finish.
then we not, as per the direction, we lost, but 3 days, but it is just not taken any step.
Dismiss with liberty. Or withdrawal with liberty.
Milord, regarding-
Bakizai proceeding will continue, that's all. The court passed the direction. Now go there, Bakizai proceeding.
The lordship may be, not. So lordship, that that process observations are made so that I could with liberty.
Heard Mr. P.K. Dekar, the learned counsel appearing on behalf of the petitioner. This is an application filed alleging willful and deliberate violation to the order dated 8/4/2025, passed in WBC number 4145/2021. 25. 21. For perusal of the said order, it is seen that the learned coordinate bench of this court had disposed of the said petition, specifically directing that if the settlement is not arrived at or not concluded within a period of 3 months from the date of receipt of the said order, the Bakija proceeding shall continue. It is the case of the petitioner that the settlement have not been arrived at or concluded. If that be so, the Bakija proceedings would continue as nothing has been produced before this court to show that the Bakija proceeding is still stalled. This court does not find the present case to be a fit case for issuance of notice in the instant contempt application. Accordingly, the contempt application stands rejected. Before parting with the record, this court, however, observes that the rejection of the instant contempt application shall not affect or prejudice the petitioner before the Bakija officer if so approached.
And never to be approached.
What? Again, here, no.
No. The Bakija
I
procedure.
said it will not preclude and prejudice.
Yes, no. Deep.
What is this,
My
Mr.
lord, this is a case filed by the wife of one Najimuddin Ahmed, who is in now Saudi Arabia. My lord, in the year 2019, he went to Saudi Arabia after obtaining proper passport. The expiry date of passport is 27th January 2026. So before expiry, he deposited the passport to the Indian embassy in Saudi Arabia. Now he wants to come home, but the police here is not issuing the renewal, the verification report for the purpose of renewing of the passport. The reason is
You have the passport or not now?
the passport is now in Indian embassy in Saudi Arabia. Now renewal has to be taken. Now police is not issuing renewal on the ground that there are foreigners cases against my brothers, against the brother of Najimuddin Chowdhury. Now Najimuddin Chowdhury was properly verified, and thereafter, Lordship is aware before issuing passport, several verification process has to be taken by police authority and other intelligence authorities. So he went there for job. Now he wants to come back but cannot come because they are not issuing the police verification report regarding renewal. So only our limited prayer is this, that police may kindly be directed to submit proper report so that my passport is renewed and I get it and I may come back to my home after 2019. That is nearly 7-8 years I have been Saudi Arabia, but I cannot come for this purpose. Now, so far the case is pending against my brother, FT cases. Well, Lordship is aware that every proceeding under Foreigners Act is against the individual person. A person may be foreigner, his brother may not be a foreigner, he may be an Indian. A person may be a foreigner, but his brother may not be because, yes, man. Because many persons here who took Jyoti Basu was born in Bangladesh, but she was India. Some persons left there, so they are Bangladeshi. But Jyoti Basu became Indian. So similarly, Manmohan Singh was taken
No,
part.
my question is, how will you come back without the passport?
That is my prayer. Police is not issuing that verification report. So my passport is not renewed.
No. Your passport you have deposited there. So
Yes.
the visa must have expired. There is no there.
So here, this is a process that before the expiry date, passport has to be deposited in the concerned country's embassy.
Understood.
And from here, police verification report will go, and then that should be renewed. Then he would be able to come here.
So, no.
Page 18 may be seen well.
Now the passport has already.
This is a process, page 18 we have taken. If the police verification is required, page 18. Initiation of police verification request for your passport application, file number so and so, date so and so. So they are not issuing verification report. So earlier they issued, but now they are not issuing. If earlier they did not issue, then I could not go to Saudi Arabia. Now I have gone, now after a few days, Saudi government may arrest me also. Because I am remaining there after expiry of passport expiry date. On the other hand, I cannot come here because police is not sending the verification report. So my position is litigant.
Yes.
Not given to verification was not given. Because there is no such document. The next
No,
day,
First and foremost, unless he declared to be a foreigner, that person is by declared to be a foreigner by a foreigner's tribunal.
unless and until he
He has to be, he has to be considered to be an Indian citizen having had the passport.
Yes.
So if you are not going to give it, the Indian embassy can renew it. The Indian embassy can renew it. There. They can renew it because if a person is outside, in a case that a particular passport is lost when you are outside, you just need to go to the Indian embassy and they will just with the police report.
Yeah.
And on the basis that you are allowed to come over to India. Only on that basis, nothing more that is required. So therefore, you obtain an instruction in this regard. Okay. Issue notice who appears for the central government. State government, central government, you appear for all.
and for the state law.
You have been, your power has been cut. Huh?
I can appear for both. law.
You are central government.
Yes.
It's the BDECA Act. Issue notice making it returnable on 24th of April, 2026.
That may short date because anytime I may be arrested in Saudi Arabia.
Mr. Counsel, it is closed. Court is closed.
Need influence.
Day after tomorrow, court is closed.
That's not the opening.
So the opening is on 28th, so I'm having it on 24th. You have made the mistake of approaching this court so late.
No, I visited several times to police. They are saying we are not issuing because yes,
So no, it is your fault. You have approached this court late. If you had approached it last week, I could have passed an order. Issue notice making it returnable on 24/4/2026. Mr. B. Decker accepts notice on behalf of the respondent numbers 1, 3,
1 and 3.
1 and 3. Mr. S.S. Roy accepts notice on behalf of the respondent numbers 2,
4,
4,
5,
5, and 6. The extra copies of the petition will served upon the learned counsels during the course of the day. The petitioner herein is the wife of one Muhammad Nazim Uddin Chaudhary. The petitioner's husband was issued a passport on 28/1/2016, bearing passport number N685-8433, which was valid up to 27/1/2026. The petitioner's husband works in the Kingdom of Saudi Arabia. And prior to expiry of the said passport, the petitioner's husband submitted the passport on 4/12/2025 to the Indian Embassy in the Kingdom of Saudi Arabia. on the basis of the said steps being taken by the petitioner's husband, a proceedings was initiated for carrying out necessary verification. Necessary police verification by the respondent number 5 and 6. In as much as the petitioner's husband is a permanent resident of the district of Huzai, the delay in carrying out the police verification had resulted in putting the petitioner's husband in a precarious situation, wherein without having a passport, without having without having a precarious situation, in as much as with the petitioner's husband at present is staying in the kingdom of Saudi Arabia without a valid passport. The respondents herein are directed to apprise this court on the next date as to why the police verification have not yet been completed. In addition to that, the respondent number 1 and 3 shall also apprise this court as to why the petitioner's husband cannot be issued a passport, a renewed passport, pending the police verification. List accordingly. Problem.
Compensation. So petitioner is the unmarried sister of the deceased who had been murdered by the accused.
Issue notice making it returnable of 15th of May on 20th of May 2026. Mr.
1-4.
S. Roy, SS Roy appears on behalf of all the respondents.
For 1 and 4, Lordship.
What 1 and 4?
Lordship. 2 and 3. For 2.
You appear for 3 also.
Lordship. 1, 3.
1, 3, and 4. And Mr. So-and-so. There is no R.A. Chaudhary here. You cannot appear on behalf of. Has she given you a power of attorney? So, Mr. She is there within the jurisdiction of this High Court. R.A. Chaudhary appears on behalf of the respondent number 2. The grievance of the petitioner hearing is that the petitioner, who is the unmarried elder sister of the deceased, late Dharmendra Medi, had applied for granting of compensation in terms with the Assam Victims Compensation Scheme 2012 as amended by up to date by submitting a representation. However, till date, the said representation have not been considered, and it is under such circumstances the petitioner has approached this court. The respondents hearing are directed to bring on record their stand by filing the affidavits on or before 15th of May 2026, pending disposal of the pending notice, it shall not be a bar on the part of the respondent authorities to take effective steps for considering the representation of the petitioner as per law. So,
Okay. Why not here the petitioners are six in, but they are the elected Gau Panchayat member of Lordship Bashbari Gau Panchayat of Hailakandi district. Lordship, plot was happened in the year 1993, Lordship. A plot of land was donated by one Abdul Jalil Borwiya, Lordship, for construction of a Gau Panchayat office, Lordship. But for nearly more than 3 decades, Lordship, no office was constructed over the same plot of land, Lordship. And now, due to delimitation, Lordship, the said land was, Lordship, situated extreme border of the present DP, Lordship. So now presently, Lordship, suddenly after, although there is a Lordship title suit filed by the donor, Lordship, that was pending, Lordship. So in the disputed land, Lordship, the authorities started construction of, suddenly, Lordship, started construction of the DP office, Lordship. The petitioner already chose and identified a plot of land which is centrally located. And the donor is also given a Lordship affidavit that he is ready to donate the land for construction of the DP office so that the office can be accessible to all the peoples of that DP. But that was ignored. So now the construction already started over the said plot of land.
Who has filed the suit?
Sorry, Lordship.
Who has filed the suit?
Suit original donor of that plot of land, Lordship.
You are.
No, we are the Lordship elected Gau Panchayat members, 6 Gau Panchayat members. So we concerned about the Lordship wastage of public money. Along with that, Lordship, the accessibility of the general people. Because the DP office, which now they have started construction, Lordship, that is extreme border of
You
the
are the heir of the Gauh Panchayat Basbari.
Bashbari Gau.
You are.
We are the elected Gau Panchayat member.
So you are the Gauh Panchayat. Why you are not appearing in the suit and seek an injunction?
Lordship, because we are nowhere, Lordship, connected with that land, Lordship. We just concerned about the Lordship wastage of public money because Lordship, as there is a disputed and this is a better superior land is there, Lordship, which we have identified. So, and that the owner is also ready to give that land,
So
Lordship.
now the Panchayat wants to construct there.
Panchayat started construction, Lordship. In
Who has started constructing?
Lordship, the block development officer, Lordship, along with the Lordship present president, Lordship.
Huh?
Present president of the Gau Panchayat, Lordship.
They are doing it.
They are started construction. As the said land
And
was
you are members of the that Gauh Panchayat.
that Gau Panchayat.
So why you are not fighting out there? Why you are moving this court on the 226?
Because we have already, Lordship, filed representations, Lordship,
So
requesting the authority.
file a suit. What is this? Why should we look into all
We
this?
have no, Lordship,
Well,
block
this
us
type
to
of
file the
cases we
suit.
should not entertain. Huh?
Well, we have no
Lucas,
locus to
Lucas,
file
no,
suit.
Lucas. No. Where, who to construct, why not to construct? Why are we going to look into this? You are not a donee. You are concerned with public money.
Yes, Lordship.
Okay, let it be. You're not concerned with this. Where is your representation?
Our representation is page 18, Lordship.
What is this?
Submitted to the chief executive officer.
Public email regarding the location of the detail may only be taken by giving type. In the world with the big. Yes. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. S. Dotto appears on behalf of the respondent numbers 1, 2, 4, and 5. Mr. So-and-so appears for the respondent number 3. The petitioners herein, who are members of Basbari Gauh Panchayat, are aggrieved by the decision of the respondent authorities, more particularly the respondent number 4, 5, and 6, in taking steps for construction of the Gauh Panchayat office in a land which have been donated by certain members of the public. It is the case of the petitioner that petitioners that the land in question, that the construction of the GP office should be done in some other area, which would be more convenient to the public and transportation. And in that regard had submitted a representation on, what is the date?
Worship, that 15/12/2025.
15/12/2025, before the respondent number 6. The said representation having not been considered, the petitioner has approached this court. This court, having taken note of the materials on record, is of the opinion that the authorities concerned, who are the respondent numbers 1, 2, 4, 5, and 6, having in-depth knowledge of the as to where the Gaon Panchayat office should be, for the advantage, so that it should be, do not find the present case to be a proper case for exercising jurisdiction under Article 2 to 6 of the Constitution. First, you have a free land.
Freeland.
Where?
Worship, that worship, at page 16, Lordship, relevant page 17, Lordship, and NOC was executed by one.
NOC won't do. Mr. Counsel, donation,
That
Give.
he-
not NOC. Tomorrow he will ask for money.
No, Lordship, he requested that if authority is ready, then he will, otherwise, if authority is not, did not come, Lordship, then he will not able to execute the deed.
Under such circumstances, this court does not find any merit in the instant writ petition. First, according the writ petition, stands closed or is rejected. First, it is, however, before parting with the record, this court, however, observes that a rejection of the instant writ petition shall not preclude or shall not act as a bar on the part of the respondent authorities to consider construction of the Gaon Panchayat office in an area which is convenient to the public.
This matter, this issue in fact is coming for the third time before Lordship. Once Lordship, we filed a RA and then judgment was passed. And in that, the respondent Dilip Mujumdar filed a writ petition. Lordship disposed that off and then the direction was not followed. Then we filed a contempt case. Recently, in March, the contempt was closed, but we were given liberty to file our objection if necessary. Lordship,
You don't want to go to civil court, go to a civil.
No, Lordship, why should we go to say, already the revenue board had asked them to do something. They did not do, and then they say, go to civil court. That is what, Lordship. Lordship, the revenue board's direction. Civil court, there is no necessity, Lordship, because joint patta was given and the hearing itself, Lordship, it was a farcical hearing.
What was the direction passed by me?
In the contempt or in the
Main case?
page 45, Lordship, that is the judgment in writ petition.
What is the decision? Who has made the settlement? The deputy commissioner.
Yes, settlement officer. In 92, settlement officer had made. Direction was to correct that the joint should be removed. That was the direction, and Lordship also uphold that. Then just because we filed the contempt, Lordship, they did this thing, and they on our face they said ki again, please look at civil case karo, tar pisot ami korim. And
Notice making it returnable on 22nd of May 2026. Mr. SS Roy accepts notice on behalf of respondent numbers 1 and 2 and 4. As regards the respondent number 3 and 4, and extra copies of the petition be furnished by tomorrow. As regards the respondent number 3 and 4. Why are you making the 4 a party by name?
because he passed the order.
Huh?
No longer as the deputy commissioner.
Lordship, but he passed the order.
You are alleging the malafide?
Yes, yes. I'm alleging because the notice, Lordship will notice the notices are given to that person. Hearing was held by respondent number 5 and the order is passed by respondent number 3. And on the day, on 27, there was no date. But later on, the copy which was handed over to me in the before Lordship in the court, when the contempt order was passed, there was a date.
Regarding respondent number 3 and 4, steps be taken by way of speed post by tomorrow. The petitioner herein have assailed the order dated. Respondent dated 26/2/2026, passed by the respondent number 2, whereby the petitioner have been relegated to the civil court for redressal of its grievance in accordance with law. The learned counsel appearing on behalf of the petitioner submits that the said order dated 26/2/2000, the impugned order dated 26/2/2026 have been passed perfunctorily by the respondent number 2.
3.
Respondent number 2.
No, 3. 3.
In order, just for the purpose of getting rid of just for the purpose of not complying with the directions passed by this court in the judgment and order dated 9/11/2023 in WPC number 6395/2010. the learned counsel further submitted that the impugned order clearly shows complete non-application of mind. And this aspect is apparent from the fact that the hearing was conducted by the respondent number 4. Respondent number 4. And the order was passed by the respondent number 2. The learned counsel further submitted that taking into account that the respondent number 2 and 4 have passed such order with malified intention, with malice in facts, comma, the said, the then existing, the then, the then, the then deputy commissioner, as well as the additional deputy commissioner, have been arrayed personally as respondent number 3 and 5 respectively. The respondents herein are directed to bring on record, the official respondents herein are directed to bring on record their stand by filing the affidavits. In addition to that, the private respondents are also directed to bring on record their stand by filing the affidavits on or before 18th of May 2026.
Hello, please.
Very pleased, Your Lordship.
But days,
In this case, Lordship, what has happened is, Lordship, the petitioner who is now a government teacher, during her period of unemployment, Lordship, he is,
reading up your bank account,
yes, Lordship.
how much?
The lien says 2,40,000. The lien amount in my blocked account says 2,40,000. But they have blocked my CIF also, Lordship. My entire CIF has been blocked. Meaning that I have opened a new salary account where my salary is deposited, that is also blocked also. I cannot withdraw my salary also.
Issue notice making it returnable on 24th of April 2026. Mr. N. Goswami accepts notice on behalf of the respondent number 1, 2, and 3.
These are the agencies which have 7 to 17 are the agencies which have raised complaint against my account, Lordship, for which my account is blocked. I have sent
Extra copies of the petition be served upon Mr. N. Goswami, the learned counsel by tomorrow. As regards the respondent numbers 4 to 17, the petitioner is directed to take steps by way of speed post by tomorrow. It is the case of the petitioner that the petitioner maintains a bank account, savings bank account,
and
with the respondent number
4, Lordship, the state bank.
maintains 2 bank accounts with the respondent number 4, bearing saving bank account number 2010 99933 8903 at IIBM branch Hanapara, and account number 44754 198 675 at new Gauhati branch opened on 19/12/2025. The petitioner's customer information file number is 86125573164. On account of certain complaints, certain emails received by the respondent number 4 from the respondent number, emails received from the respondent numbers 7 to 17. by the respondent numbers 4, 5, and 6. Both the petitioners' accounts have been frozen on
On 17/1/2026.
17/1/2026. The petitioner had submitted various requests for permitting the petitioner to operate those bank accounts by keeping a lien on the amount which is alleged to be proceeds of the private cybercrime. However, the respondent authorities, more particularly the respondent number 4, 5, and 6, have not permitted the petitioner to operationalize the said bank accounts. The petitioner further, who is a teacher, is facing a lot of difficulties on account of the fact that one of the accounts pertains to is a petitioner's salary account, and the petitioner is not being able to access such funds.
And she has never used that for any other purpose.
Taking into account the above, the respondents herein are directed to apprise this court on the next date as to whether the petitioner can be permitted to operationalize the bank accounts of the petitioner by keeping a lien on the amounts which are amounts found to be proceeds of the private cybercrime. Because an instruction in that regard be placed by the accounts by the respondent number 4, 5, and 6 on the next date. Ito di ba? Kalagote ito di ba? Petitioner further permitted to take steps by way of dusty upon the respondent number 5 and 6 routed to the registry of this court and file an affidavit of service on or before the next date. The petitioner shall complete and shall effect such service by way of dusty on or before 2026.
So interim, also. In the interim of any direction to operate my salary account also.
How can I allow it? I have given you this.
Lots.
Can't give you
Well,
that.
obliged, lots.
Because the moment I do it, it will have margin consequences.
Obliged.
Yes. Rana construction, what is this? Why the tender is before me? Why a tender matter is before me?
Whether the registry has discussed this matter before construction.
Okay, tell me, what is it?
My lord, a scheme for tender was published in the Assam Tribune at page 21. It was published on my lord 3rd of March 2026. Page 21, in the second paragraph, my lord. Details may be seen from 6/3/2026 at the website www.assamtenders.gov.in. This is the official website, my lord. From 6th, that bidders can check the tenders. Page 22, the next page.
Page 24, then we are going to go 22.
22.
Okay.
The tender was published on 13th of March 2026. And my lord, bid opening date was 16th of March 2026, only 3 days. As per the, my lord, this Assam procurement rules, the civil appendix to the rules, 21 days may be given for submission of tender.
Period is over, 16th March.
My lord, a technical bid, since I am not I could not participate due to lack of time. The technical bid may open, my lord, but my lord, the financial bid, as per my instruction, the financial bid is not open and the tender has not been finalized yet.
Then?
Lordship, turn to page 29. What is the main, the word is my lord, Assam procurement.
I have it. Yes.
Rule 10 of the procurement rule.
What did you say?
Rule 10(1). Rule 10 relates to my time frame for procurement process.
So you mean to say that the detailed notice inviting tender, which was published in the newspaper, say you can see from 6/3,
Yes,
but
it was published on 13.
it was, it could be seen in the website from 13/3.
13. And the date
And it was available till 16/3.
16. And 14 and 15 were Saturday and Sunday.
And 14 and 15, Saturday and Sunday, the computer does not work.
It works, my lord, but my lord, we have to procure documents, my lord. Online submitted.
Yes. What is this?
Act remains, others participated.
Others participated, those people who know that you are going to issue only on that route.
Notice was on second or third itself, 3rd of March, notice was there also.
You do one thing. Please show it out here that it was on 6th. Yeah, download date is 6/3.
Not only kindly see the schedule at page 25.
What is this page 24?
Page 24 is the, my lord, that, it is uploaded in the website. my lord.
Ah.
This is the tender for the work. Next 25 is the time schedule, my lord.
Ah.
The publishing date 6/3,
Ah.
document download start date 6/3, document download end date 16/3. But my lord, document was downloaded on 13/3. It is reflected on page 20. As per the advertisement, we can check it on 6/3, but it was uploaded only on 13 March. my lord. Page 22. Document download date is 13. Clarification 13, bid submission 13.
So what was appearing on this date? How do you take a photograph of this?
My lord,
Page
this is
22.
available in Assam tender, ma'am.
It's still available. How did you take a photograph of this?
On 13th, my lord, Assam, it was published on 13th on the Assam tender. ma'am.
Ah.
From there, I can take a printout. ma'am.
No, is it available now also?
My lord, since the financial bill is not obtained. Yeah, ma'am. Because
So
after
this
finalization,
cannot be altered.
yes, it cannot be altered, but
This cannot be altered. Chalo. We should notice
Not-
state it's not to grant the tender.
so far as page 24 is concerned, this is the uploaded tender, detailed tender. ma'am.
Understood, but if it was published on this, because you can't manipulate this.
No question of manipulating.
So
sir. It is
therefore,
uploaded document.
no, therefore the question is, if there is anything to do with page 22 and 24 are having relation, because work is safe. Now, if this document is not AI generated, now we have a lot of AI generated. If it's not AI generated, then in that regard, there's something wrong. If there is not AI generated,
No, firstly, Lordship, this is not print out. This is only a screenshot. It appears, Lordship.
understood.
From
So
the face
it
of it,
appears
Lordship,
to be a
it appears to be a screenshot.
So therefore, you find it out.
That is what.
Like you want, we'll have it tomorrow. Get this thing whether it will right or wrong. In the meantime, don't.
The fact still remains, Lordship. I am not submitting anything because I have not taken any instruction. As per his instruction, technical bit has already been opened.
Over.
Finance is not yet over.
But if it is.
And Lordship will see the date.
This is the thing which has.
Lordship, on 13, you were aware that the tender has been lately uploaded.
No, therefore, I put the question to him.
Not.
Is this available today? If it is available today, how did it? It is why I put the question to him. So whether this is available today. If it is available today, and if it shows that it is on 13th of March, it is violation of the, payment. If it is not, anyways, you are no, you can't give it now. Because model code of conduct is doing this.
In
No,
any
we are
case, Lordship, it's not going to be open now. In any case, Lordship, it's not going to be open now. If the financial fees have not been.
Cannot run the contract now in, for, in the
Fourth of May.
in 4th of May, you can't grant it. So anyway, just find it out.
Take up instead of the vacation. Vacation. No. Whenever take it, no, not to take up after vacation.
We issue notice. Stay, not to be.
But stay, I'm not, I'm objecting because.
Object. You are at liberty to object and
Not
I am
on-
at liberty.
Only because of the fact that others have already participated.
So what? If it is in violation of the rules, rules is violate. If it is not, because the work is exactly the same, that is why I was reading it. If it is exactly the same, it was issued on so and so, but it was not published still in the website till 13, then there is a violation. It requires
That situation, Lordship, let me have the instruction. Tomorrow, Lordship will take up. And then if required, Lordship will pass the interim order tomorrow. Some amount of instruction at least, Lordship. Let me have.
I need out around 4 o'clock. Where it is, just see the authenticity of it.
Tomorrow.
They. Okay. Not tomorrow, let this matter with me. It's the matter tomorrow. Right. It's the matter tomorrow. Mr. Pinack shall obtain instruction as to the authenticity of the screenshot of screenshot enclosed at page 22 of the.
Released to eviction on the ground that the petitioners are encroachers, they encroach the forest land.
Is that a tribal reserve forest land?
Yes, reserve.
Yes, who is going to argue?
My lord, in fact, my lord, the petitioners, village, they, my lord, their village is outside the forest boundary of the reserve forest land line. So earlier they had approved this honorable court and.
That I know. But that, who is going to?
Yes, my lord, series of cases are also.
Joint verification. By committee forest. And a map is also not annexed as well as GPS data can also be annexed. And for that, I respond. By affidavit, by. Immediately after the way of. Until then, some protections and we provide.
Listed in the admission. We have replied to the admission items mentioned in the admission column.
Yeah, I can do that. Item,
Item 20, 21, 22, 23, 24, 25. 20 to 22. I'll affidavit, I have called the affidavit in the morning.
ওনার রিকোয়েস্ট রেকর্ড on the what is it's matter
Sir, Gogoi, please come to page 208. 208. Abdul Karim, Abdul Karim. Two zero eight number, the map. What are the houses in between the blue stretch?
Hello?
These are the houses.
Yes, ma'am, these red dots are houses. The blue is the entire forest area. Houses of petition.
And which portion has been found to be Patta land? When you see page 202.
Pilots.
The original of this document. We have the original of this document.
Which document this is?
When verification is start, you have made photocopy.
I have to. Oh, well, it's not there within this file, man, because it was filed very hurriedly. Perhaps it laid in office. Office. To bring. Otherwise, when it's filed yesterday, copies were served only today. Copies could be served, my lord. Certain copies of this affidavit were served only last evening. I can bring it.
I am saying so. The the fact that this particular Lutumoy Reserve Forest is a forest made in the year 1928. So therefore, inside the state reserve forest, there cannot be panchayat, whatever the panchayat does in CGT. Because that will have to be done after 1947. And the panchayat came into, was made only sometime in the year 1990, because the amendment which was made and thereby chapter 9 and 9 was brought to the constitution. Now, after that, it has happened, the 94 Act has come in. Prior to that, if these panchayats were held, then so by the 80 Act, the panchayat was taking something to issue patta or whatever. Panchayat. Now the question is, this particular document which you have enclosed, can you come to page 202? Read the line, paragraph 4.
During the areas with claim patta rights, during the joint survey, two blocks, block 1 and 2 were found contain land parcels where claims of patta rights have been recorded. These portions are kept outside the scope of the present eviction operation pending a final decision by the competent authorities. The coordinates of these ambiguous land parcels are enclosed in Excel C1.
Excel C1. For me, which one?
C1 is page 207.
Huh?
Page 207, C1. C1, it is Excel C1. Because I put a conclusion here. These are the patta numbers.
patta lines.
Yes, patta lines.
So these patta lines you are not.
We are not touching them.
Now, Mr. Ria, you are any of these persons?
No, no,
Page 207?
we are not. But these are our very close and adjacent area in our neighbors. They have the patta.
Now, what is this election? Because why I'm saying it's connection page 206. On top you say it to be election. What election is this?
That pilot, not civils, we have to read the whole document, my lord. Not civil, can you see page 202, one, it's encroachment blocks, the list of that starts with, it's B1, B,
202 says about block 1 and block 2.
yes, but block
These
one,
are patta lands.
These are pattas.
my lord, only the annexure C, my lord, it's the patta length, annexure B, which is, I'm referring to at page 202 at the top, my lord, those are the coordinates. Those are the areas where eviction was carried on.
You have carried out this,
No, certain, no, not carried on, these have been demarcated lines.
but there is nothing out there. Not a single, these are all what you call paddy fields. Page 206, block 3.
Yes, sir.
These are all paddy fields.
My lords, the area has been under encroachment for a very long time, my lord. From to 19, perhaps let us assume from 1947 or 1950s, my lord. So there's no question. There's some crops were standing there, but my lord, the jungle has been totally finished off. It's been covered by all cultivation activities.
Now tell me, how do you get these coordinates?
My lords, we have nowadays the devices are there, my lord. We use those devices. We compare everything in land stuff is there because what you will see at page 202 signatory, my lord, we circle officer below him there is a LRA, my lord. Sumit Kumar Mojumdar, land record estimate. So both these things collate, my lords, collate, and they have a mechanism, and they take out this, my lords, longitude, latitude, GPS coordinates.
Because your boundary is here. Boundary is 199.
Right.
57 change at 66 from the point of river Gauhati. River at bearing so and so, so and so. In the last mentioned point to the Lutumai Nodi. So this is being given, no?
My lord. And we are not, we have used these, my lord, earlier that when notification was made, my lord, the river, course of the river and its origin was used, my lord. It still remains like that. The river has not in any course.
But I would ask you because why I'm saying, well, see, these are very difficult to see where you say the red line represents the boundary of RM. Where is the red line? Do you see any?
In that case, Lordship will bring the entire records, my lord.
Original instead, because.
Yes, yes, yes,
Because,
yes.
yeah.
Otherwise, because my lords, they will also draw one map, some with some.
No, we
right?
are not concerned with other map. We are concerned, we take it when the map has been drawn by authority, we consider it to be there.
Well, we'll bring the original.
And give a bigger picture of this,
We'll have a big map, big.
because then we can keep it on the call. Because these area inside, yes, on the side of it, these are areas another, I mean, we will look into it. But here you cannot.
Right.
That day I went to an ophthalmologist and asked for a specs, and got a new spec. But with my new spec also very difficult to see what is. Like we can glasses.
Same condition for us also. Same condition.
No, this legend, what is mentioned out there, there are blue color represents to Lituma area and red color, there's red color also. Represents. What is this?
Those blocks which have been spelled out in my lords, that report that we are compartmentalizing everything. Those areas which are not touching, it is a different block. Those areas which are contemplating eviction, that's a different block. Lordship, let us have this. I will bring a big map. Particular big.
map. And see the fact is whatever may be. there is it so. Interestingly, the Assam Gazette of 1928 is 15th of August.
Miles, yes.
Now, Mr. Irrespective of that,
Milo.
in those cases which are in the reserve forest,
Milo.
I don't see you have a case.
And that's why, my lord, these the maps which has been produced before my lordships, my lord. My instruction is that, my lord, these are all Google generated maps, Google maps, which we are relying. Now, for that, my lord, what I have a little research I have made yesterday night, the Honorable Apex Court judgment says, my lord, under such circumstances, my lord, Section 65B, certificate of the Earlier Evidence Act is required, my lord, to authenticate regarding in such a serious issue, my lord. Those judgment I could not bring today, my lord, but I will try to make it satisfy my lord, my lord. Whether these maps can be conclusively proved before my lordship that this is the area where we have enforced upon you. Now, what they have done, my lord, they have captured these maps by flying some drones, my lord. From the ground level, from the petitioners, my lord, I have come to know that some drone mapping has been done. Now, in what manner? Because, my lord, when the notification was issued initially, I don't know whether that record is available with the authority or not. My lord, regarding at that relevant period of time, obviously, my lord, there could have some map or records could have been maintained by them, my lord. My lord, I am, my lord, respectfully submitting, my lord, yes, my lord, if we are within the reserve forest area, my lord, then our chances is very limited, my lord. But for ascertaining, my lord, because this is our livelihood, this is our life, my lord, entire issue, my lord, if we are now being get evicted, my lord, we will become homeless and shelterless, my lord. Now, my lordship is the only hope, my lord.
Becoming a homeless or not, that is another question.
My lord, my lord,
Because we are also to look into it, that is the reserve.
my lord, my lord. Forest protection.
Secondly, if it is the case of this Pongia thing out there,
My lord.
they are in reserve forest.
No, my lord, prima facie, the map which they have brought in, my lord, it appears that
It is your specific case that you are in reserve forest. In the Tongia,
Tongia issue is there. Tongia is a different issue, my lord.
but
They-
how do you have a right?
Right, my lord, to remain there, my lord. No, my lord, we have we have been allowed to remain there as a Tongia cultivator for the purpose of forestation. For the purpose of cultivation, we are aiding to in the purpose of forestation. We are not destroying the forest, Milord. We are there employed.
Mr. Bhuya, are you
Man.
saying that you are remaining out there for forestation where
Because
that entire forest is not there?
no.
It has become barren lands out there which is full of paddy fields.
No,
There's
Milord.
not a
No,
forest.
Milord. This the paddy field area is not of the Tongia area, Milord. It
Which
is,
one is the Tongi area?
Milord, the map which they have exhibited, Milord.
Which area?
Like,
Where does the Tongi people stay?
Milord, for that, Milord, I need the instruction. I have to sit with the petitioners, Milord, along with the map, Milord, which they have
There's
exhibited.
nothing out there.
My lord, my lord. No, my lord, the Tongia is, my lord, I have to admit that the Tongia people can only have the right within the forest, my lord, and they are residing therein with the due permission and approval of the government in accordance with the rule, which allows the, my lord, Tongia, my lord, they have, my lord, I will bring all these rules, my lord, by filing the rejoinder affidavit, my lord. They have the
What
rules.
You don't need to bring it by way of a
My
rejoinder.
lord, my lord.
You don't require to use the rule.
Well, under the Assam Forest Regulations, there was a provision of certain village, certain provisions giving concession to certain class of people. These Tongia is a procedure which has been adopted from Myanmar. Some people, when forest is notified, some people are brought in for a limited point of time, so they can help us with the growth of that canopy for that big horticulture of the canopy forest. Once the forest grows, well, uh, they are driven out, managed. And those rights are not also in a successive with the doesn't go with the succession management. They cannot go son to father, father
But
to son.
where we see a forest.
Yes. And in fact, my lord, that very rule has been set aside by a learned single judge of this court, my lord, which was also challenged before the division bench. Division bench was said like this provision of the Tongia or whatever it is, my lord, is in a conflict with the Forest Conservation Act, so it has to be set aside.
Tongi cannot happen, any right cannot be given. Because the right has to be created by way of a statute. Where is the statute for that?
Thanks.
No, statute rule is there, my lord. They have, my learned friend has produced the rules the other day, my lord, regarding how the Tongia concept is come into and what is their right under the rules. So, my lord,
Now the Tongias have resided when?
Not,
35 years.
since, the 1970s or 60s like this, 74, they have their existence.
So they have been permitted to remain there by some document.
Yes, yes, my lord, we have annexed those certificates, my lord, and is,
In which we could be.
my lord, take up.
We have dealt with this, if this Abdul Karim, you have denied marriage. That those certificates will be annexed, para 5, page 191.
My lord, the best Tongia petition is, my lord, WPC 1690. My lord, Abdul Noor and others, my lord.
Huh?
Abdul Noor and others is where all the petitioners are claiming, my lord, Tongia. And for that, my lord may be pleased to take up these certificates, my lord, with the document they have issued. My lord.
Finally come to page 90 of the other one. Page 1694.
1694, page 19. Yes, my lord. My lord.
Page 19.
Now page 70 is the document. This is of 1998. How can this type of document be issued after the Forest Conservation Act?
My lord, these people are, my lord, residing before this, my lord, 1980, as per my instruction, and later on this certificate has been issued to show that they are, my lord, this is an inhabitant of Longjap, Podumoni, Tongia, Bongaon village, allotted 4 bighas of Brookside land, including, so, my lord, this land where he has no any outstanding payable till to date. See in his record, he is 1974, my lord. The original I have annexed that below, page 70. This is issued on 98, but the record says that is 1974 from it has been drawn up.
Very difficult to understand. He has no outstanding payable to the Forest Department till today. Seen his record, he's 1974. That doesn't mean.
This is the certificate they have issued by the Forest Authority. Now, for what reason, for what manner, they invest.
Sir, done or the issue.
Well, in the other petition, that is, in Abdul.
And what are you doing out there?
Mal,
In the Estonia, what are you doing?
we have been employed in the various forest activities. There is some plantation is required to be done.
Where is the plantation? There is
No.
not a single plantation you have to demo.
No, not in nearby the area where we are residing, but some outskirts or in the hills areas, they are employing us.
What?
If, plantation is required to be done in some forest areas, then we have been engaged by the forest.
Where you have to reduce everything to nothing.
No, it is,
Yeah, I think you should people out. No, Mister, we have to be strict on this. Yeah, you see what is wrong? Where is that the Abdul Noor's case? Where is this Tomia thing?
page number 169, may kindly take a look, This is a letter issued to the Deputy Commissioner by the Joint Secretary Forest Department, settlement of land in Paki Reserve Forest and Lutuma Reserve Forest under Tongia system. This department memo number so and so. In inviting a reference to this department memo quoted above, I am directed to clarify that about 700 evicted families from so and so who have no land and no place to go may be given temporary shelter under the Tongia system in so and so area. I am further directed to say that about 300 evicted families of Lutumari Longja Reserve Forest after proper screening of the families by the committee. An application submitted by Sri so and others praying for settler under this system in the reserve forest is enclosed herewith in original for your disposal. It may please be noted that screening of all evicted families for providing temporary settlers may be done properly, and the committee already appointed by this department memo number so and so dated so and so should be given the responsibility to select deserving people out of the evicted who should be provided with temporary
So
shelter.
why is it written to the deputy commissioner?
No, this has been written
How
by.
can the deputy commissioner who is in charge of revenue write anything, do anything to that effect?
Madam.
How can the deputy commissioner give something in the Pangya in respect to the reserve forest? This document doesn't appear to be right.
Now, some of the certificate also,
Telegram, see, we have no place to go, may be given shelter under the Tongia system. What is this government done? You can't destroy the area first. Let the DC do whatever they feel like giving it in all other wasteland, but not in reserve forest. Very difficult, Mr. Commissioner. I think in Abdul Khalik also the Supreme Court said forests constitute one of the most vital natural resources of the nation. They are not merely repositories of timber or land capable of alternate use, but complex ecological system indispensable for maintaining environmental balance. Forests regulate climate, so and so. In a country as ecologically diverse and climate change is 51 AD, at the same time, Constitution demands the environment will be pursued through lawful means. Mandate to clear the encroachment from forest does not authorize an arbitrary action. The Constitution does not decide that so and so. We express our concern to maintain the rule of law while ensuring protection of the fourth paragraph, 3, 4 establishment of our concern. No, Mr. Gogoi, kindly come to page 208 of the page in 1690 of 2026. Page 208. This is an affidavit which have been filed by the Forest Department. Isn't it? From 206, it is being reproduced. In Abdul Khalik's order. Yes. Now kindly come to para 7. My lords. Yeah, the concept of forest village is unique concept in Assam. A person entitled to stay in forest village finds his name mentioned in the statutory register called Jamabandi register maintained by the forest department for the forest village, and the person holds a document for the land under the possession. Additionally, the title holder under so and so are also legally authorized to occupy forest land and are not liable for eviction. This is your stand. Well, now kindly say that the individual whose name is mentioned in this register means the register of Jamabandi register or holds rights are not unauthorized occupants. However, there are several unauthorized occupants who have encroached upon the land outside the Gaon Panchayat limits, and in some cases inside the Gaon Panchayat limits which fall within the boundaries of the reserve forest. That it may be pointed out that the right to reside in the reserve forest area falling within the Gaon Panchayat is inheritable, but not transferable. There would be a separate set of documentary evidence showing authorized occupation within the reserve forest areas which are falling under the Gaon Panchayat. Any unauthorized occupants residing in reserve forest areas albeit falling under the Gaon Panchayat is liable to be evicted following the same procedure as pointed out above. So therefore, you categorically say about a Jamabandi register. You have a Jamabandi register for Lutumai register.
It's there. We have it, not now, but we have it.
Does the petitioners have any name out there?
No,
Lord, that instruction I have to.
they don't have name.
No, my lord, Jamabandi means, my lord, they are maintaining a record, my lord. For these Tongia people also, they are maintaining a Jamabandi register.
And so therefore,
My lord,
as
my
we
lord.
could see from Abdul Khalek,
My lord,
there are two rights which
Yes,
emanate from a reserve forest. One is by
2006.
way of a Jamabandi register because of a village forest. And the second is
Panchayat,
a right under the 2006.
My-
Don't come under 2006.
my lord,
But whether your name appears in the Jamabandi register,
my lord. That is the designation.
It's not there. I can.
Lord, my lord, forest, my instruction is that, my lord, the forest department is maintaining a register, my lord. Now, whether that register is amount to a Jamabandi or not, my lord, that I cannot fairly submit today before my lord, my lord. But my lord, it is,
no, but
my lord.
it is the stand taken by the forest.
Yes, yes, before the apex court, my lord,
And page 208
my lord,
is the contents of the affidavit filed by the forest department.
forest department, my lord.
So they themselves,
Admitted, my lord.
although in a reserve forest after 1980, you cannot use for non-forest purposes.
My lord.
But by filing this
This
affidavit
affidavit, my lord.
and giving an undertaking before the Supreme Court,
Aye.
the forest department admits to certain respect.
Aye.
Meaning thereby we maintain a reserve.
My
Job.
lord.
Now, if it is a government register, if they have done it after 1980, this is another thing. Could they have done it?
My lord.
Now, it may be a thing that if your name is there, you may not be entitled to be evicted,
My lord.
but you may be asked to leave by giving you some alternative.
Alternative.
accommodation. If their name is
Yes, yes.
well, something else, because here you categorically say that they are not unauthorized occupants. Problem lies with that, paragraph 8.
Because my lord, we are still maintaining some forest villages because we need some people who will clear the path for mounts and for those issues, my lord, to address some issues related to
Now,
the
have
department.
you put it in your affidavit as to whether there is any forest village within Lukumba Reserve Forest or the
Yes.
Popani Reserve Forest?
There are.
Certain I have any issues. Yeah, we have done that.
My lord. My lord, may I just bring into my lordship that.
Para 9, man. Para
That's
9,
what-
page
that's
31,
what
9.
I should be. Because you see, next day, para 9 of the affidavit filed by, in which case,
It's Abdul Noor.
para 9, na?
Para.
That the forest owner has not created any village in here. That is why you are saying that there is no forest village.
Yes.
And hence no Jamabandi exists for reserve forest. This is what it is, your specific stand is it. So for to my reserve forest, there is no,
No. But in Abdul Khalek, my lord, that relates to Doyang and Nambot. There are a few certain, there are 12 number of villages, my lord, forest villages. We maintain a Jamabandi of terror.
Mr. Bhuya, I
Well-
think on this aspect, you need to file a reply.
Yes, yes, my lord.
Paragraph number 9, they say that there is no prohibitions.
But my lord, in the, some of the document which we have annexed, my lord, says that there are some forest villages in Lutumai also, my lord. My
Where,
lord, may kindly turn to page 155
of which case?
of this Abdul Noor matter, my lord.
Page 155.
155.
No, 150.
No, my lord, may, 158, it starts, my lord. Borpani, these are also within Lutumai, my lord. If my lord, maybe please to found that, my lord, column. Third column, my lord, name of villages, Longja, Podumoni, Hatipara, FB. My lord, this FB denotes for the forest village, my lord, which they have not denied. And
Where? At page 158.
159, my lord, I am referring to, yes, my lord, some forest villages are also there.
We are
This
concerned with
FB
Lutumai.
refers for and I am specifically referring to page 159, my lord.
Which one?
This Longja,
Longju,
Podumoni,
Podumoni.
Hatipara, forest village, my lord.
That is Hatibara.
My lord, my lord.
Is Hatibara part of Lutumori?
Lutumai Reserve Forest, my lord. That's why, my lord, some clarification and, my lord, stand is required to be in my reply affidavit, my lord. And secondly, my lord, as my lordship has just gone through the order of the Honorable Apex Court, my lord, the very line, my lord, which my lordship has just gone through, it says, it is there stand in the affidavit, my lord. I'm just referring, my lord, that the concept of this, my lord, it is at page 208, my lord. Paragraph 9, my lord, just for a moment, my lord, I am reading it, that it may be pointed out that a right to reside in reserved forest areas falling within a Gaon Panchayat, my lord, is inheritable but not transferable. My lord, that this means that they have admitted that within a reserved forest, a Gaon Panchayat can exist, my lord. Can exist.
My lord, Gaon Panchayat is a PRI institution. It's PRI. So when the fruits of Panchayati Raj came, my lord, these forest villages, which were in the Jamabandi, admitted forest villages, they should enjoy the rights of that local self-government. That was the purpose. That doesn't create any right of titlement. That was confined to only those afforded forest villages.
But you are saying it is inheritable.
Inheritable condition, there's a condition, my lord.
What
Inheritable,
condition?
my lord, that rule, my lord, so we'll see. The forest village rule itself, my lord.
The rule is very dangerous. Rule 1930 rules is finished. There won't be any foresting.
My lord, that is, my lord. No, it's like. Well,
You do one thing,
My lord,
you file your reply.
my lord, I will.
And as per you, this Lonju Podumoni is a forest village
Mal.
falling within
Lutumai.
my
Mal.
reserve forest.
Mal.
This is Borpani. This is
Borpani.
Borpani Reserve Forest.
Borpani and Lutumai, my lord, is connected and adjacent area, my lord, and Longja, this in Lutumai also there, my lord.
Okay, you will give a reply.
My lord, I will bring all those things on reply, my lord.
I'll just point out one thing, Lordship allows me. Lordship goes to the first title of the petition, my lord. Move the petition, starting with petition number 1 to petition number 18. Their addresses may be looked at. If they are so called for forest villages, Hatipara. This Hatipara forest village.
Hatipara.
Petition number 19.
Heroni. Village
Page
Heroni.
27.
Heroni is where?
Kerala is somewhere.
Heron is, my lord, it is within a Lutumari range, my lord. The Aadhaar card and voter cards, my lord, which has been issued to us, my lord, deals with these addresses, my lord.
Understood, but you would not get your address somewhere else. Where is
No, no, my
Heroni?
lord, it is a very adjacent area, my lord. Geographically,
No,
very
Heroni
adjacent.
is outside. You cannot, you are having it and you are occupying this.
My
You
lord,
cannot
my
have
lord.
it.
That also, my lord, I'll clarify, my lord.
Like you said, Hatipara.
Huh?
If there is any purported forest villages there, if any forest village is there, assuming I'm wrong, my lord,
Ah,
So petition number 18 to 36, it's only after that, I will see these adjustments are doesn't reflect any forest area.
Ferroni, all these are Ferroni. Yeah, one is there. 19 is there.
Yes.
Longzhu Pudumuni.
19 to 37.
These are all
After
forests.
37 is forest area stop.
Ah. But they will have to, so therefore, Longzhu Pudumuni is Lutumai.
Well,
Is it Lutumai reserve forest?
it's to my.
If it is so, then your statement at paragraph number 9 would be wrong.
Paragraph number 9 of. Paragraph 9. No, then it's 4. I'll stick to it.
Huh?
Page 319. We'll stick to that. There's no forest village in Lutumai.
So this is in Borpal. So therefore, this matter is somewhere. Borpani, all these things are taken up together. Well, let us see one of these orders, personal orders, where it is. Yes. Where is the order?
Milord, speaking order, Milord.
One of these order in this.
It's 307.
307.
Started 284.
Huh?
My lord, in Abdul Note case 284, my lord, this is started, my lord.
Where is that person at petitioner number 19?
They annex all.
Milord, we go, not many California's, my lord.
These are all Ferroni. Why you have not enclosed the others?
Milord, we can bring on record all, we have received all the notices, Milord, timely, Milord, they are issuing.
These are all Ferroni.
My lord.
Ferroni
We have this person has also received notices.
But Ferroni Tongia has been mentioned to be,
My lord.
this is within Lutumon. But if you have one speaking order for the purpose of those petitioners from 19 to so and so,
Yes, we have.
saying it to be in the speaking order to be Lutumoy,
Lutumoy.
then it contradicts what is stated in paragraph
Milord,
number 9.
I have all those, Milord. Those I will bring on record, Milord. Yes, Milord. I got the point, Milord. Sorry, Milord, because it has been so hurriedly filed, we are apprehending, Milord. Many petitioners, Milord, more than 200, sometimes, Milord, become voluminous, Milord.
And one fine thing, why not? Supreme Court gave them a chance to adduce evidence regarding their title, leaving aside the forest village issue, my lord. Assuming, my lord, that's it, not a forest, they should have presented some document of land document here, my lord. Even there also is no single document they have given, land document. Some,
It's okay. They don't give, it's okay. No problem with that. The only thing is, we need to find out, is it in the reserve fund?
much.
And you see, you have created your own problem by filing that affidavit, where you have created certain things which is exceptional, which is not found anywhere. Now, there cannot be a creation by even by the state government to do anything after 1980.
Well,
Prior to 1980, yes, there might have been some right to be constricted somewhere. But have a look at the 1927 Act, Forest Act. How can you so? I want to protect the reserve forest, but the fact that you should also give me some handle,
my lords.
not in a manner by which you have done it. Now, having a forest village is another thing. But whether they have their names, you see, one thing very clear, however, there are two things from the Supreme Court's order. One is Jamabandi register, and the second is so and so. The 2006 Act.
That act of
2006 Act, they say they don't fall within. They say. The only case is whether they have their names in the Jamabandi register. If they don't have, you say that there is no Jamabandi register. But he says that yes, may not be there, but their names are there in that village, which is a Gaon Panchayat, so and so. So if there is a reserve forest, a reserve village, or there is a village within that ambit of the Lutumwa Reserve Forest, then you have to have a Jamabandi register. Where is that? When we'll have it? When?
Any date, Lordship.
Let's have it on. We need to finish it off, huh? You giving you last thing. We'll have it on 23rd
23rd.
at 2 p.m. for final disposal. You file your affidavits by 20.
Fine.
Okay. And in the meantime, whatever additional affidavit you want to file, you file it by 20.
Fine.
Give any copy to. On that aspect, clarity.
Right.
Heard the learned counsels appearing on behalf of the parties in the present batch of petitions at length. The various affidavits have been filed by the Forest Department of the Government of Assam. In 5 of the writ petitions, huh?
We have filed five.
Five of the writ petitions. Mr. So-and-so submits that he would like to file a reply on the said affidavits. Taking into account that the matter have been substantially heard, this court fixes this matter for final disposal on 28/4/2026 at 2 p.m. In the meantime, the petitioners shall be at liberty to file a reply on or before 23rd of April 2026. Pusta. The Forest Department, if so advised, would be at liberty to file additional affidavit on or before 21st of April 2026. Pusta. And there is an undertaking which has been given, we extend it till the next date.
That undertaking was given by. Philip, Mr. Goswami, I can fit in his shoes, my lord.
Okay. It is taken note of that on the last occasion, an undertaking was given by the Additional Advocate General, Assam, that there shall be no steps taken for eviction. And it is under such circumstances, this court did not pass any interim directions. However, taking into account that the Additional Advocate General Assam is not present today, this court is of the opinion that as this matter, as the present batch of writ petitions are being taken up for final disposal and have been substantially heard, certain interim protections are required to be issued pending the next day. Inasmuch as without passing such orders, there is a likelihood that the very cause of action for which the instant writ petitions have been filed would become infructuous. Accordingly, this court directs that till the next day, the respondent Forest Department shall not take any steps for eviction in respect to the Lutumai Reserve Forest as well as the Borapani Reserve Forest, which are the reserve forests, which are the subject reserve forest in both the writ petitions.
In Doyang and number also in Abdul Khalek case.
Doyang and
But
in some other matters which are there, that is why I passed this order. You have a matter? I think it a notice issue kori returnable on so and so. I want to file your reply. Hey, accordance the order. Take along with this. Interim order will be. We'll see when it is there. Today I've been busy in 2 matters. They will give you.
Registry has got to find it one list. And government also filed one affidavit in opposition in this case.
Now, have they provided the segregated list?
Lordship. Lordship, that list has been submitted before Lordship.
After 10-3, where is the segregated?
On 18/3/2026, Lordship, there.
Segregated list. So these are components. So these matters which are there, where the MP MLAs are complainants, we have to bring them outside the scope of these proceedings.
Lordship, in that case, Lordship, provided that accused should not be FP or ML. In complainant, maybe the MP ML, and in some cases, accused are also MP or ML.
Pick one for one D. So now we have 23 matters
Lordship.
which are prior to 2016. And what are the scope of these CRs? CR 2981. এই দুটা হল এইটো তো এই দুটা তেতিয়া amicable settlement agreement. But he is the respondent, no? I think release is not wrongly made. But see, kindly come to annexer A. That's it. Serial number 3. Not true. Accusing the Ramakataran. Now, vote.
That is why, Lordship, if complainant, the cases where complainant and the MP or ML is segregated, then we'll have to look at who are the accused also.
Ah,
And the accused list is check F. So it is necessary to compile both A and F.
serial number 10 also.
Lordship. Akil go and Koibu. And from the Lordship, flag F, Lordship, we have a look for a once, Lordship. These are the list where the MPML are accused. So unless Lordship flag A list and flag F list are compiled, Lordship, and make a common list, Lordship, it cannot be ascertained which case is to be, Lordship, retained for trial and which case has to be segregated. One more, Lordship, homework has to be done in the respect. My humble submission.
Okay. Now, tell us on the other thing, Mr. Additional Advocate General, about paragraph number 9 of our last order.
Yes.
Either the state would continue with the present public prosecutors in respect to those cases or appoint special taking into account that is the mandate of the direction so and so.
Well,
Now,
an
what?
affidavit has been filed.
Yes.
Your lordship kindly see.
Well, page 117 are the existing.
Well, page 109. That's 8. Paragraph 3H. Page 1.
Now, Mr. Additional Advocate General, we want to know one thing. See, the mandate is this, as per Ashwini Kumar Upadhyay's judgment, these MP MLA matters are to be disposed of. You do it with the present set of public prosecutors, the additional public prosecutors or the assistant public prosecutors, or do it by way of the existing ones. Or appoint somebody else. We are not concerned. We are to have these persons there who are appearing in these of.
Yes, well, we have indicated in 3H of page 109 that the earlier imperant public prosecutors, additional public prosecutors, and extreme public prosecutors, all these are not released. So they are
We
continuing.
understand. We ask that for the background submission that public prosecutors are not cooperative. Because of the new selection. It was the understanding.
Right.
Then there was a statement by the additional advocate general saying that no, we will not release them, we will accommodate.
Yes.
Our concern is not that. Our concern is whether these courts,
Right.
there are public prosecutors and it is being run day to day or whatsoever, it is proceeding properly. Because in this context, a statement was made that due to this non-cooperation, it is proceedings are delayed.
Right.
So that is the core issue. We are not concerned it. We have put weight.
But possibly the purpose of putting this paragraph 3H is there. The earlier, there was a confusion, my lord, that whether the earlier imperant public prosecutors will be released That is the reason they were possibly not cooperating. Now that a stand has been taken that they are not released, that means immediately there is a question of releasing them. So they will continue. Now, whether they are participating, then all these courts are meant by public prosecutors or additional public prosecutors, where this MPMLA cases are pending, more particularly in those cases. Because there was a proposal also that if necessary for those proper rules, appoint special public. Yes. In that background. Not concerned. So give us a list against each of the cases where MP MLAs are accused.
Thereby assigning the public prosecutor additional assistant, whoever it is, or who is existing. That this is the person who is going to do. That will solve, because we are not concerned with the entire criminal jurisdiction. It's for any other bench to look into it. Our mandate is only for the MPMNs.
Yes.
So we are therefore, we want you to give us, now you have appointed these 239 persons.
Yes.
And there are some existing public prosecutors or additional public prosecutors whom you are already not keeping them. You are not going to discontinue. So therefore, it would not be a difficult on your part to assign each of these cases to one of the public prosecutors. Maybe one public prosecutor may have 2, 3, or 4 cases. Thereby we pinpoint who is the person responsible for the particular. Then it would be easier for you also to interact for an early disposal. Where's the director of prosecution?
Today, one the additional deputy director. It will be helpful for them also to monitor. My lord? For them also it will be helpful to monitor. Yes, yes.
We collect the student names from its district.
I think that is the only way out.
Yes,
we can
that
proceed.
is facilitated.
And in the meantime, we ask the registry to prepare the list properly.
Right.
The list that is not the manner in which we have sought. The list was to be segregated. One is there should have been a list prior to 2016 and after 2016. One. Now, in these two lists, only those persons who are any MP MLA or former MP MLAs who are arrayed as an accused would be there.
Not as a complaint.
Not as a complainant.
Yeah.
When it is when
The two MPs are fighting each other. Then it will come.
then it will come.
Yes, ma'am. If there are two MPs on both sides, then it will come.
So the person, if your MP MLA is a complainant, he doesn't get an advantage. It is only an accused who is an MP MLA or former MP MLA, then the question needs to be expedited.
The list was mixed. Some are complainants.
Now also they have not,
They have not done.
they have made it in a very,
And one thing that while collecting the names, you are what are going to do, please don't come and say on the next day with a list that 5 are still vacant, nobody is there. If you identify that these are no public prosecutors that are there, come with us a list where everybody is in place.
It's not that come with a list and we'll do it something. We do it and come back.
Actually, now the problem has gone. It was not that time when you
Anyway,
it was a transitional period. New appointees were, new recruits were not appointed, not posted. And old were thinking that they are going to be ousted. So that was a transitional period for 2-3 months.
Good, now you give us the list.
Now,
Now against each case, you are to assign the role of a public prosecutor or additional whoever it is. The state is asking. Okay, we pass the order then. Heard Mr. Look, T.A.G. Mohanta. Hello. Mr. Mr. P.P. Dr. the learned counsel appearance on behalf of the Gauhati High Court. We have heard Mr. E. Mojumdar, the learned additional advocate general, Assam, as well as Mr. So-and-so, the deputy director of prosecution, who is present in person. First, an order was passed we passed an order on 5/3/2026, thereby directing the registry to segregate those cases wherein MP MLAs are the complainants from that of the others. Subsequent thereto, we passed another order on 10/3/2026, thereby directing the registry to prepare another list whereby priority is given to those cases which are pending till 2016. In pursuance to our orders passed on 5/3/2026 as well as on 10/3/2026, a list is being prepared and had been placed before us. We are of the opinion that the list so prepared is not in consonance with the order passed by us on 5/3/2026 as well as on 10/3/2026. We therefore direct the registry to again prepare a list, 2 lists. The first list, 2 lists of all cases wherein MP / MLAs present as well as former who have been arraigned as accused. Out of the 2 lists, 1 list shall be of those MP / MLAs present as well as former against whom cases are pending up till 2016. And the second list to be prepared are in respect to those MP / MLAs present as well as former against whom who have been arraigned as accused post on or after 2017 till date. Next. At paragraph number 9 of our order dated 10/3/2016, we sought for an affidavit to be filed by a competent authority of the state of Assam on the question of paragraph number 4, we sought for an affidavit to be filed by a competent authority of the Home and Political Department of the Government of Assam as to how the state of Assam would be engaging the public prosecutors, the additional public prosecutors who have been appointed in terms with the BNSS, as well as those public prosecutors and additional public prosecutors who were appointed earlier in terms with the provisions of the Code of Criminal Procedure 1973. In pursuance thereto, an affidavit had been filed by the Deputy Secretary to the Government of Assam Home and Political Department of the Government of Assam, wherein it is mentioned that 24 public prosecutors, 75 additional public prosecutors, and 140 assistant public prosecutors have been appointed under the BNSS. It is also mentioned in paragraph number 3H that the state of Assam would continue with those empaneled public prosecutors, additional public prosecutors, and assistant public prosecutors of all districts who were engaged prior to the recent appointments being made under the BNSS. Taking into account that we have now segregated the two lists, of which priority is given to those cases pending wherein the MPs, MLAs, former and present, have been arraigned as accused in the we direct the state government to assign in each case public prosecutor, additional public prosecutor, assistant public prosecutors appointed or empaneled under the previous regime or the present BNSS against each case which are pending against MP, MLA, former and present till date. The said list be placed before us on the next date list according.
Also would like to fix a date.
We are giving you a date. This will follow with the other one.
Yes.
Give you a date after that. Yes, what do you say about the notification dated 13/2/2026?
Well, we have filed an affidavit.
Public procurement conviction. Hey, yung mato. Public procurement conviction. Ini yata semua.
Yes. So for the effect of this notification, 28th of January 22. One C also. C is direct from the spot purchase and request for quotation.
Why not?
Instead of NIT, my lord, request for quotation is my lord. Closer. Then perhaps my lord, it will be out of the. Silently quotation.
It will come under one A also here also.
Yeah.
One A.
Yes, well, ultimately, whatever
So
is
if
there
you
in
go to the
objective-
definition of urgent work,
My lord.
The act. In the rules.
In the room. Procurement rules. Supreme Court judgment is there. It's a respect of life. It is said.
So we say that housekeeping for court purpose would come within the ambit of 1C and 1E.
Yes,
That will take care of it.
We are not seeing mention about this kind of definition also. Looks that notification may change, but this will be. In my.
Therefore, it will come under 1C and 1E. And therefore, it is exempted. Now, that is one. So the notification, we say this notification to be, although there is a mention to disclose that particular clause, but this is exempted in terms with this notification, which is not overridden till now. So that will do. But now, this particular, so is there any problem with the housekeeping? Housekeeping, any problem?
But for this notification is concerned, look, we have recently issued a communication. There is not what happened.
You know, before going into this, let me tell you. You know, our high court is the high court where it is the height. There is a, we are in huge embarrassment. Manipur, Tripura, Sikkim, even other high courts, forget about that. Now, on 11th and 12th, we have a, what do you call, some seminar. National conference. National conference, it's a seminar of all judges who are there in the information and ICT, computer. So there we are to show which are the high courts which have gone paperless, who have not. And you know, it is only us. And the reason is we have the hardware. Yes. But we are not in a position to hardware only for 10 courts. I know. No, hardware is for 10 courts. 10 courts. But we don't have the money for the purpose of getting the software. Requests have been made time and again to the state government to provide the funds. Funds have not been provided. So we are the only high court now, Gauhati High Court, who is going to tell the entire, the Supreme Court, the judges from the Supreme Court, as well as all the high court judges who will be present there, who does not have a paperless court, Gauhati High Court. My brother gives an example. You can actually see Kerala se thanai.
And this Foral is of 2024, my lord.
Huh?
This Foral is constructed was pertaining to 2024. But I can
No, even
this topic-
Sikkim, I think on May 11th, no? 11th or 12th, they are having inauguration of the peoples. And you may, I'll show you the hardware. This is the hardware. No, this is there. It is completely functioning. Therefore, you see all these things out there. It is this, you can operate it, you have a stylus, everything. But we don't have the software for the purpose of getting bringing the e-file to here for you.
In fact,
In
my lord,
ballot-
in this regard, on some documents I have collected, my lord, kindly have a look. It will give some details or insight with regard to the amounts. How much amount we asked for, how much released.
Malad, the last financial year, Malad, 3.85 crore was sanctioned by the government of Assam for setting up of e-court, paperless court. But 5.7 were have been expended. But
What is the requirement, by the way? Total demand given by the High Court for
3.85 crore.
total? No.
The
So
total
phase one,
requirement,
phase one,
no, total requirement is 37 crores.
Yes.
Malad.
Of which 28 crores come for establishment of paperless courts in 19 courtrooms of the principal seat. And 9 crores 80 lakhs for payment of bills for one connectivity in the district courts of so and so. Now, of all this, after doing all this hardware, we have 1 crore 40 lakhs. If 1 crore 40 lakhs cannot be used for for all this purpose because it is that we don't have the money for that.
And that 19, that 9 is not, that hardware is ready not for 19 crore. It's only ready for how many crores? 5 crore.
5 crores, 5 crores. Only 5 crores.
Mr. Gogoi, we'll have to show a bright face to the entire country.
At least let it be, because you see, we have already started, you must have seen the e-filing which is going on. Now, earlier we were digitalizing all those matters which were disposed of. We have done to a particular extent disposed of. Now, new which are filing is being done are done through e-filing.
Yes.
There is still a gap amongst it from the pending as well as the disposed of. There is a gap out there. With this particular gap which is there which will start. But as of now, we can have 5-6 courts which can be made functional. Taking into account that with these 5-6 courts, we can start with some benches like bench 4, 5 and all. Maybe we may have some difficulty with the bench 1, taking into account that getting the own. Now we are being told the district courts, those disposed of matters have already been digitalized. So therefore, we did not get those records. We can very well call it out here. It will come here, tag it along with this. Nowadays, we are also told that these district courts reports can also be tagged along with the land record branch, and thereby they have digitalized. Now, once they digitalize, when we initiate a matter or ask for a particular document, we can just pull it from there. This is happening everywhere. So only thing that once it is being paperless, we need to have already, we are making it as regards how to mark exhibits in the trial courts. Because marking of exhibits will have to be done. So these are looked into, and for that rules are being prepared. But at least where marking of exhibits are not there in the principal seat and all, we can have it. So, and we are only asking for this 4-5 crores initially. So that once it is being done, it will become better. So that is one. So that is goes with this thing, because you will be getting the data from here. Everything has been given out here. Because although only an amount of 5 was sanctioned by the government of Assam for financial year so and so, the sanction amount was used for payment of recurring expenses like bills for WAN connectivity in the district courts of Assam, AMC of servers installed in the district courts of so and so. And you won't be surprised that there's a huge amount to be paid for, although NIC has given us a free internet connection. Internet connection is free, but to get it by way of a particular line, and maintain it is around 22 lakhs. This is in million. Huh? It's 22 lakhs because it comes from Dispur or somewhere. That line is from there. So it is being dug and brought in here. So this is how we have this line. Anyways, I think something can be done for this. At least we need something. How much we need in the airport now? Around 3.85 or something. How much? 4 crores. Around 4 crores we need for making these 4 or 5 ports operational. Because then we have already had. Huh? 1.4 is available. 1.4 is available. So therefore, without having that
1.4 to,
Huh?
1.4 is over, Milord, now.
it's over.
It's
So we need 4 crore now.
total. At least to run this 5 crore. Okay, do this some proposal.
Proposal is there. It has been already sent long time back.
Annexed.
No, 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 no.
Hmm.
570 was sanctioned, but that
Point number 5.
we should.
What?
385 later on thing, but তারপরে এই 386 তো আমি normal
More than this amount is spent. 5 crore is spent. Already spent.
Mr. Jamir. Yes, any development on that High Court? Yeah, Mr. Jamir, is there any development on the High Court front?
During the visit of the Honorable Chief Justice on the last occasion, the contractor as well as the other officers that the PWD department, they have given an assurance that the inauguration is slated to be in the last week of July. So desperately we are hoping that something can be done before that. And by end of July, I believe we can inaugurate the new High Court. If everything goes well. And so far as
It will be good for Mr. Siti Jamir. His house is next to the new High Court building.
for the last 8 years, I'm coming from that place to this place. And fortunately, I'm the first person to reach the High Court premises because my chamber is next to High Court also. Before traffic jam, I reach by 8, between 8 to 8:30 always. So once it is shifted, then others will follow what I have been doing for the last 8 years. And fortunately, during the last 5 years, 8 years, I have not solved even a single adjournment on the ground of traffic jam or for that matter delay and traffic lordship.
Mr. Jamir, I would request you, being the president of the bar, you just talk with the registry as regards the furnitures for the bar.
Lordship, yes.
Because that what is required. Because what remains from the last time I visited out there, only the land connection remains and furnitures.
Yes.
Everything, the transformer, everything has been fit out there. So only thing is this furniture. So
Lordship.
taking into account the bar's room, the furnitures and all have to be duly taken note of. Because otherwise later on they may not put all these things which may put it difficult for the bar.
Lordship.
And apart from that, on the other building which is under construction, of which it is a G+6, I suppose, on the year. So there is a construction on the top floor. It is given to the bar for the time being, I'm told. So that construction needs to be looked into.
We will coordinate with the registry as well as with the contractor also.
Yes. And Mr. Imsong, what is the present status of creation of other posts?
Lordship, with your apology, by the order dated 10 March, regarding the administrative control of the MTS,
3 MT.
3 MTS. So I will be allowed to file a affidavit only on the next sitting. And again, the registry has submitted 40 posts, that is a top priority post.
Okay.
It is under process in the department.
Because once the building, because if we are thinking of starting sometime in the month of July,
Lordship.
taking into account the size of the building, we have this MTS post at least made, because without that, it would be next to impossible of running it. You may do one thing, you may have, I think the government of Nagaland has a lot of excess posts, excess persons who are employed in other places be brought out here by creating these posts out here. Something has to be worked out. Okay. We do one thing, we would not further prolong you. You are asking for time. We'll fix another date and give you the time in that regard. And Mr. Jami, kindly have a look at this aspect.
Lordship.
You may just go, otherwise almost 5 o'clock. We take it up out here with the other lawyers from principal seat.
It's an opportunity for us also to be associated with the lawyers from principal seat also.
Okay. Yes.
Now, my lord, the MCC is in force. So at this moment, my lord, MCC is in force, my lord. Model Code of Conduct, my lord. Till that time, my lord, there is some difficulty, my lord, to move for the budget, my lord.
You are saying that some money will be paid from the government to the High Court, and the High Court will get influenced by casting vote. Why do you have the MCC?
We can definitely have.
MCC is only model code of conduct that don't do anything by which you can influence a voter.
Considering the magnitude.
Our Chief Justice is not a voter here. No. And magnitude for a state of a, if Nagaland, if we have said that, they would have said that, okay, no problem, we are going to do it. Nagaland is making a high court of 600 crores.
Only for the time being, my lord. That's
what time?
We can definitely make a move.
Election, we are not asking prior to 9. You do something. But the proposal can be mooted and proceeded with, at least for these 5 courts. Then what happens? You see, it's a bit face saving for the Gauhati High Court also to say, because you see, amongst all this, we are at present having 4 high courts, 5 high courts. Sikkim, Assam, the Gauhati High Court, Manipur, then Tripura and Meghalaya. All 3 or 4 are having, and only this we are not having. It doesn't look nice.
In principle, my lord, government has taken steps, but then it did not happen. My lord.
This also have been clear much earlier. Just come up now.
No, that's we know, but this was being at the administrative.
This was going on since 24.
Long.
It would have been days before this bank balance, so that we all along, but it will be taken.
Okay, you look into it.
It's not put on the state as well.
It doesn't look nice. Taking into account that on one hand, we are saying that the Assam government and the state of Assam is prospering. And the only state amongst the 5 high courts, only high court out here which doesn't have it, paperless.
At least we are having 5 for 5%.
Agreed for 10. We have, but we need only for 5 now. That would be for the time being, it will take care of it.
At least we can say that we have started the project and it's being done.
As a pilot project, as a pilot.
Now, what has happened as regards the CGM?
Yes, that was good. I have got.
The CGM, the status is,
Huh?
From PWD, I will raise it. I will know.
It was asking order to release.
You can tell me regarding the
You see, what has happened, I tell you one, the seriousness of the issue involved. We have stalled the shifting of the CGM court by passing an interim order out here. Now, the problem which is being faced is day before yesterday, some portion of the building has collapsed. It's in a way, this is that
Some injury or something.
so I think if if the authorities, they don't do it, then we think we do undoing. If they don't want to shift, they do let them not shift. Let us have it in the place where you are asking them to shift. Let us have it there. Huh? Remove them from there. You have to come up with some solution out there. If they don't want to shift, let them not shift. Let us take over that other area, because here we are concerned with the fact that these people, although they don't want to shift, it is okay. In fact, that day, the administrative tribunal says that they don't have cases also.
not only one case, so far as I have heard. Only one
That
case and
also is-
8, Lord, my instruction is that only one case and 8 employees. Not, with all due respect, my lord, I don't think, my lord, this their adamancy should be appreciated vis-a-vis the requirement of the state as well as the institution. Because CGM, my lord, we have planned in the second floor 6 court, and the square feet is 7,633 square feet. In the first floor, the square feet is 3,745 square feet, much lower. So 6 court cannot be accommodated in first floor. So they should not, if they are adamant, and lordship can pass order, my lord. If they are adamant and state is unable to do, showing their helplessness.
And we have passed it. The thing is that we may have to then take it up with the state government for not providing us the infrastructure. This has broken down. So we take it some place where will it be? Somewhere.
Yes, Mr. Gogo, see, and Chief Secretary impress upon them.
Yes, yes.
Sort out the
Sort out the issue. Yes. I think that will
And then
resolve the
you
issue.
have to make comment against
Yes.
the failure of the state. Why should we pass an order of eviction of somebody? You are expert in evicting.
My lord, I think this instruction,
Secretary duty.
this observation, my lord,
In fact, on the last order, para 9, lordship reflected something regarding passing some order with regard to solve this
See,
issue.
we are not passing any order today, but Mr. Gogo and you impress upon the Chief Secretary that this is enough.
And we'll blame the secretary because this is not our job. To pass an eviction. Let him ensure that infrastructure is handed over to High Court. That is his constitutional responsibility.
May I just point out one thing, but instead of waiting for another 1 month, since last time Lordship has expressed sufficiently in para 9, can that order be passed today? It will, because of the CGM falling, my lord. Because it will help my friend also.
Mr.
I'm sorry. I'm sorry.
We have no problem in passing an order.
Correct.
Mr. Gugoi, we have no problem in passing an order. And if we pass an order also, the thing will be very embarrassing for the state. And it will be very embarrassing for a tribunal also, but they are not listening. Then we may be constrained to pass certain orders, which would be very demeaning, because we respect. It is the state who is to provide the infrastructure. And as such, we, as the state, as the High Court, we are respecting it, okay. But our expectation or our, what you will say that our tolerance are to a particular limit. We cannot go to a particular extent that you can. Now the building has been demolished. I mean, it's in a bad shape. Some person has got hurt. Will be justified in passing an order directing you immediately to hand over this and take over this. But for a tribunal which is being constituted under the Administrative Tribunals Act, would it be proper to pass an order of eviction by the High Court to the basic meaning for that? So if the authority is not there, who is the president of the year? The chairman of the Administrative Tribunal, let us call him. And next time, I'm telling you, we are going to call him. It seems that he's trying to act very funny. We'll call him next time, and if he doesn't come, we'll issue a warrant against him. Tell him.
Mr. Ariz Ahmed, he's Mr. Ariz Ahmed, deciding officer. He's additional chief secretary level officer.
Additional.
We will pass an order asking him. If he doesn't vacate it, then we may have to, we'll ask the chief secretary to look into this aspect. By next, on the reopening, we'll again have it on 24th, 23rd. We'll having it. In the meantime, if they don't vacate, we'll ask the presence of this person. Making it vague. If he doesn't vacate it, it's okay.
And Mr. Gogol, we will also expect at the same time that by the 20, who will not record, by 24, this area should be handed over to the contractor for that project. Second.
Yes, ma'am. You have to hand over. This is not, we are concerned that it is a civil court also, it could have been managed. It is after all the criminal courts, wherein a person's right to liberty and all these things are concerned, and you are putting it in this manner.
There are multiple appeals. That project is stalled. We have licensed the order. Now contractual will raise escalated bill because you have not been able to hand over our thing. So these are multiple effects.
In fact, in my report, my lord, I suggested for removal of the revenue court also. It would have given us the entire building in my report, my lord. I suggested the revenue court it can be shifted because it's the property of the state, my lord. There are
Where will they shift?
no, it's for
Where will they shift? They are not in a position to give us a CGM court's place. You are saying that they will shift. Where will they shift? Yesterday, there was a writ petition before me pertaining to that place where you were suggesting that CGM, that flood control office and all, the flood control of the water resource, that irrigation department. That is also being litigated where the state wants to give up that. Yesterday, I was taking up that matter of Mr. Samir Ali. That is the land where Khadi board was there. The Khadi board has already vacated. Now the remaining area is where the government said that we don't want to acquire. Now they want to hand it over. Where? They don't have any land.
They don't have any land for the court. Very good.
Not for the court. I'm not saying for that board of living. Board of Revenue also no matter.
That thing never get explored. I only suggested placing
See,
it.
Mr. Das,
Fine, my lord.
we, as an infrastructure bench, we
Yes,
are not actually having a adversarial litigation.
For the convenience of the,
We understand.
yes,
That may be a good proposal, but we cannot impose certain things.
fine, my lord. If the CGM can be accommodated, second floor, because one
This
floor
is
we
the
still have,
bench
yes,
for-
fine, let the revenue code be there, but why I am making reference to revenue code because
No, I understand.
second
You
floor
have
is
given that-
shifted. Now, he,
It looks very nice. But the fact is, on the practical, now see the predicament of the sport or even to the officers out there. They are always under the threat that when the building will fall down. And that building is not fit now for running a course.
any small jerk will enter.
So we pass the order, we have it on 23rd. In the meantime, either they vacate it, let the chief secretary take it up. And thereupon, if he doesn't vacate, then we have to pass orders for that person.
Not one.
So that is there for that.
Can I have some observation in the code for that this code of the two the following copy to the chairman. Official. What is it? Page
Oh, yes, yes.
Only point for the.
No, don't worry. All the other orders we normally give it to you only.
No, Mother.
I understand that you want it to be marked to him.
To him.
No, no, because we'll say that we'll have to pass appropriate directions to him, a copy being given to him, asking his facility. Now, what about the Kaziranga guest house?
To be cancelled because of one benefit was the first one. The second page. Last paragraph. The process to.
No, well, you will get wider participation once you have the administrative approval. The reason why you are not getting is because of that. Nobody would like to do it. And then file a petition before the court for money.
That is not religion.
Yes, that is the reason. In fact, that is what I told Mr. Secretary, on the last occasion when I was to him, when the infrastructure, building and infrastructure committee was sitting. Didn't I tell you? Who is going to participate? I know it. Because this is what happens. Once he clearly says that no work should be allotted unless the administrative approval is not granted. Why will the person take up that heading with the black caption mark out there to the effect that no work to be issued without the administrative approval? This is very dangerous.
Then also updated makes make a note.
We do one thing, as regards the update pertaining to the others, we keep it on some other day. We'll make it very clear. But as regards the CTM, we have it on 23rd.
Yes.
Look, one issue.
And this we make it very clear. It will fall under 1C and 1A and 1C.
Fine, my lord. Lord, one issue is there, I have given a letter dated 4/4/2026. My lord, here what has happened, my lord, the head of accounts, that is the housekeeping expenditure, is not included in the vote of accounts, which will go for next 2-3 months. Because vote of accounts has been created and our housekeeping, the head is missing there. So for next 2-3 months, there will be no money for housekeeping. 4/4/2026.
So that situation has been clarified by finance department.
That clarification I have received, but I have failed to understand that clarification, my lord. Because it say it will be apportioned. Reappropriation. So reappropriation means, my lord, distribution. If the head of account is not there, where from, if you collect it from somewhere, where will you place? So I wish.
No.
No, am I going to hear the concerned head of account? What is the concerned head of account? Tell us. Your letter dated 7th April says,
Yes, ma'am.
where there is adequate budget present to the concerned head of account. Which is that concerned head of account?
That earlier.
There is no head of account is there.
Earlier, no.
What took DS? Wait a second. No.
How much money do you require now?
12.5 lakhs to 50 lakhs. 12.5 50 lakhs. How many months?
Outstanding for 2 months, I think.
2 months. 2 months.
2 months outstanding.
That includes the salary of these Sula people.
Yes.
They'll have to create a head of accounts in the VOA. Otherwise, they are saying that they are apportioning the
Take up with
money.
the commissioner and sort of.
For placing
I got this information, I get the finance results, but they will take up.
But see, look at these people, they are getting around 7,000-8,000 salary.
We will work it out.
What will happen in the BU? I think
We'll work it.
We should sit immediately after BU during vacation then.
No, not necessarily, we will work it out.
You do one thing, pass the order tomorrow.
Yes.
I'll put it, though we are not going to set you. You just give me an information tomorrow. First. On this point. That is, on this, just inquire that within how much time you are going to do the review. Then we'll incorporate it in on the order. That is as your submission.
It is 2 months pending.
Because you got it only in the evening today, or during the
Yes.
day, so you just take the instruction and let us inform, or we'll sign the order tomorrow. We have this on 23rd, and the other matter, we'll give a date on the other matter.
Fine.